Massachusetts Appeals Court. It is my great pleasure to be sitting this morning with Justices Englander and Brennan, and I am Gabrielle Wolahojan. We have 6 cases on the list this morning. I anticipate that we'll take a short break after the 3rd case, so if you're sitting here and you're on the second half of the list, that's just to help you plan. I think many of you are familiar with our rules, but I'll just briefly mention that each side receives 15 minutes to argue, and there is no rebuttal. About a minute and a half before the end of your time expires, the yellow light will go on, and that's to give you a warning that you have a limited amount of time to wrap up your argument in the way that you would like. We try to refrain from asking questions during that period so that you can wrap up gracefully, but that's not a promise. So with that, I'm going to call the first case, which is 23P0290, Commonwealth versus Juan Carlos Felix. And is it Attorney Malm?
Yes, sir. Good morning, Your Honors.
Morning. We're ready whenever you are.
May it please the Court. Matthew Malm for Mr. Felix.
Would you please, you may have to adjust the microphone and don't forget to project.
Yes, Your Honor. Sorry. So as Your Honors are aware, this is a constructive possession case. In particular, it's a constructive possession case in a residence, which has, a fairly well-developed area of law specific to that. The Commonwealth has to prove a particular link, connecting the defendant to the contraband, to the area where the contraband was found. It's not enough that he shared the premises or were in the premises.
Can we back up for a moment? Because I probably should know the answer to this, but does the defendant concede that this was his residence?
No. No, that was not in the evidence. The only thing connecting him to the residence was that Aaron's rental agreement that was found somewhere in the apartment. Commonwealth didn't establish where in the apartment it was found, whether it was in.
But in closing argument, the Commonwealth said on multiple occasions the defendant and his girlfriend live here.
Yeah,
without objection.
Yeah, that argument wasn't supported by the evidence.
Could the jury infer anything at all from the fact that he was standing, while he wasn't in it, he was certainly at it at the time?
Yeah, he was in
conjunction with the piece of mail, the rental agreement, sorry.
So is Your Honor referring to his location when the police arrived?
Yes,
yeah.
I am.
So no, no, I don't think they can infer anything from that as far as his connection to the apartment. He was in a driveway beside a vehicle when the police arrived. So that doesn't provide any link, as far as him living there. Just because he's on, a driveway of a house certainly doesn't mean he lived there. That'd be too far of an inferential leap.
And why does a document found in the apartment that lists that address, that specific apartment, with his name on it as his address, why is that not sufficient evidence in the light most favorable to the Commonwealth for a fact finder to infer that he lived there?
Yes, Your Honor. And it's not because they don't. So it has to be a particular link to the area where the drugs are found. And so that letter...
We're starting at the apartment. Let's just start with the apartment.
Yeah, the apartment. So yep. Yeah, the letter was found inside the apartment. That's all we know. We don't know whether it was found in one of the 2 bedrooms, in the kitchen, right, in the living room, in the bathroom. We don't know where it was found.
Say it was in the mailbox or sitting on the street, but it lists his name and that address. Is that not evidence of anything?
Well, so it's relevant...
Or in his pocket.
Yeah. So it's relevant to connecting him to a particular room where the drugs were found. So it is relevant as far as the location of the letter.
No, I'm saying to Justice Englander's question, though, as to his residence at that apartment, leaving aside for the moment the particular rooms, 3 or 4 rooms within it, your client's residence at that apartment, why isn't a paper found in the apartment with his name, it appears to be a rental agreement with that address, not enough?
So I would point Your Honors to Commonwealth v. Berea. That case controls. So in that case, a letter was found. Well, first of all, in that case, the defendant was actually in the apartment when they entered the building. She admitted, I live here. This is my residence. A letter with a welfare application with her name and address was found in a living room closet. Drugs were found in a VCR in the living room. Right. Drug distribution supplies were found in the kitchen. And the Commonwealth found that that was, or I'm sorry, the court, the Supreme Judicial Court found that that was not sufficient to establish a particular link with the drugs.
Respectfully, and bear with me, I'm just trying to walk it out one step at a time, because residence was not a question there. It appears to be a question here, so could you just address the question as to whether or why the evidence in a light most favorable to the Commonwealth in this case doesn't at least establish that he lived there? Not necessarily in that room, not necessarily in one of the other rooms, but at that apartment, more broadly.
Well, so I think, well, I would just state that even if they could establish residence, even assuming residence was established, it's not enough. Citing Berea, I think it's all in all fours with Berea in that respect.
There are multiple, so I mean, each case has to be taken on its facts, right?
Yes, sir.
And there were multiple people present in the residence in Borea, or Borea, I don't know how you pronounce it, right?
Yes, sir.
And it was more than two, right? And there were multiple bedrooms. Here we have one bedroom that's occupied, correct?
So we have 2 bedrooms, and there is testimony from the detective that one appeared to be used, one appeared to be a spare bedroom. The issue with that has pretty limited relevance here because we don't know which bedroom the drugs were found in. There was some testimony on direct that it was found in the bureau in the used bedroom, but on cross-examination, and I cite this in the fact statement, 213 to 215 of that first day of trial, he's not sure which, he ends up saying, oh, I'm not sure which room the bureau is in. So we don't even know.
That was the second detective, right? That was the second detective.
That was Detective Hurley, I
The
believe.
first detective, though, let me ask you this, let me put it a different way. Assume that that's the case, that based on the 4-year lapse between the arrest and the trial, memories have faded or people don't quite remember the exact off the top of their head location, and there's some equivocation. Again, don't we, if we're looking at it in the light most favorable to the Commonwealth, don't we need, for the purpose of that analysis, to accept, or can we not accept that there was testimony that it was found in the occupied bedroom, even if there's some contrary testimony along the way?
Well, no, my view, and I believe it's the view that the court should take of that cross-examination, is that he walked back. He said, oh, I'm not sure. So he corrects that testimony. It's not that it was contradictory testimony. Well, it is contradictory, but he walks back his earlier testimony. So I believe the evidence is that.
It has to be pretty clear in order for us to not indulge the inference with respect to testimony on direct. It's clear. I mean, I don't think I've ever run into this situation before, but you're saying, yes, maybe he testified on direct that it was in the bedroom that was occupied, but you should disregard that testimony when doing a Lattimore test because he walked it back. Would have to be pretty darn clear, wouldn't it?
And it is clear, Your Honor.
Okay.
Yeah.
Take a look.
May I ask you a question about the record? I take it that this, I know it's called a lease, but it's not a lease for the premises.
No, Your Honor.
It's, the document we're talking about, is that, it's page 20 in the record appendix?
Yep.
So as I see it, that is a lease, a 1-month lease for a tablet,
Yes.
and it's dated July 3rd, 2018, is that correct?
I believe that is the date, Your
And
Honor.
what date was the search?
Off the top of my head, Your Honor.
I think it was maybe September 20th, 2018,
Yes, Your Honor. I
so
believe that's
more than 2 months later.
correct. Yes.
So I'd like to know in the cases where constructive possession has been based on a document that has someone's address, if you can tell me what types of documents those were. I
think that-
remember some are utility bills. Can you give me some help on that?
Yes, Your Honor. So, yeah, I think kind of the typical documents are an actual lease for the apartment, which.
Sure, this is not a lease,
That
but
is not a
I
lease
don't
for
think
the
they've
apartment.
always been a lease.
Yep. And so, this is distinctive from a lot of the typical
But
documentation.
what about, do we have other ones that don't involve leases of the premises? I think we do, right? We have just mail, but there are things like benefits.
Yeah.
I
Yeah.
remember a case involving like Social Security benefits or disability benefits or utilities. I'm wondering if you can You don't know off the top of your head?
Well, Commonwealth of Berea, so that was a welfare application. So yeah, that wasn't like a utility bill or an actual lease for the apartment where it's more of a stronger link to, the person living there. It's just,
Those were welfare benefits?
yeah, and the court said, quote, I believe the quote, it described it as a welfare application.
And do we know the date of that document relative to the date of that the drugs were found from that case?
Off the top of my head, I do not know. I'm sorry.
Okay.
I don't know if.
I'll ask your sister the same types of questions.
Okay, thank you. Yeah, so, Your Honor, I think that is, an important point, that this was it's a Aaron's rental agreement for a tablet, for a Samsung Galaxy tablet. It's the fact that he, used that address for, to procure a rental, of a device, that's fairly weak evidence of, that that's his actual residence where he lives.
Can we read, or could the jurors read anything into the fact that it was still there 2 months later? Is that do you see it as a positive or a negative or a neutral for your client?
Well, yeah, the fact that it's there, admittedly has some relevance, but it's, again, limited by the fact that we don't know where it was found. And the case law requires they have to be, it can't be that you share the premises with somebody. It can't be that you're in the premises. Not enough. They have to have a particular link, and that's a quote, particular link to the area where the drugs were found. And so we don't know where the rental agreement was.
Let's assume the drugs were found in the only bedroom that was occupied. Let's assume that there was evidence sufficient for the jury to infer that both he and Ms. Ortiz lived there. Okay? But there's only one bedroom that's occupied. Is that sufficient?
No. And we don't know because
to infer that he knew that the drugs were there in his bedroom?
Well, we don't, so that, the evidence that you laid out, I don't think, that does not establish that that was his bedroom.
Well, couldn't a jury reasonably infer if only one bedroom is occupied? And if the jury can, assume the jury can reasonably infer that he lives there. Assume that only one bedroom is occupied. That's the evidence. Can't the jury reasonably infer that he lives in that bedroom?
No, because he could be living on the couch in the living room. That's not uncommon for someone to do. There's no evidence that, they were in a romantic relationship or, that they shared the bedroom.
The warrant affidavit is not in the record, correct?
That is not.
Wouldn't have been admitted at trial, but it's not in the record anywhere?
That's my recollection of the record, Your Honor. And I would, with regard to the warrant, so it was admitted for a very limited purpose. That was just to establish why the police were there. And the court gives an instruction to the jury about that. They said they cannot use the warrant, or that he was named in the warrant, as any evidence.
Yeah, I'm more interested in the warrant affidavit, because it seems to me the Commonwealth knew a whole lot more than they put in evidence. That's why I'm asking the question. Okay. I understand your answer.
Was there evidence at trial that this particular Galaxy tablet was located in the premises?
No. My recollection of the record is that is no. They did not find anything like that.
Can I ask, you argue joint venture, we should call it joint venture, aiding and abetting now.
Yeah.
It doesn't seem to me that the Connell's theory was aiding and abetting or joint venture at trial. They don't argue it in their brief, as best I can tell. No. You just threw that in as a sort of a, just in case?
They asked for the instruction on that, so I felt like I needed to address it. I think, as you can tell from my argument, there's nothing there.
It is a constructive possession case.
Yeah.
Plain and simple, right? Yeah, okay.
Was there any evidence as to whether any other part of the premises appeared to be occupied as a sleeping area? There wasn't, right? That's a spare bedroom. So it was a kitchen, a spare bedroom. Was there a living area?
There was, a living room, yes. Mm-hmm. Living room, kitchen, 2 bedrooms, and a bathroom.
All right. Thank you.
Last question I have is, do you see any distinction whatsoever in terms of our assessment of constructive possession between Boria, where it's, call it hidden in the VCR, as opposed to in the drawer, unlocked drawer of a bureau or a desk?
No, I think it should be considered hidden in both instances, and that's, and one of the reasons for that is that, again, we don't know which room it was located in.
So I guess my question is, if it was in the same bedroom, and it's either stuck in the VCR, tucked into the little slot of the VCR, versus in a bureau or desk drawer, no difference?
Still hidden because they haven't established, even if we established that it was in the bedroom that appeared used,
Right.
They haven't connected him to that bedroom sufficiently.
No, I'm just asking, assume for the
Would
moment
be
he's
hidden to
connected
him.
to the bedroom, the drugs are in the bedroom, and in one scenario, they're in a desk drawer, in the other scenario, they're stuck in a VCR, kind of tucked into the little slot where you wouldn't normally put an item such as that, as opposed to putting it in a drawer. Any difference or any significance there?
No, and where they can't connect the person to that used bedroom, then no. And so it's hidden for both purposes, out of view. Yeah.
I don't, thank you very much.
Thank you, Your Honor.
Attorney Herron?
Good morning. May it please the court, Donna Marie Herron on behalf of the Commonwealth. While recognizing this is an extremely close case, it is the Commonwealth's position that there was sufficient evidence. The facts are what they are. I understand.
Yeah, can I ask you a couple
yes.
questions, though, because I just want to make sure I understand the factual record
Sure.
correctly? So it's only this one document
Correct.
that is the Commonwealth's evidence of residence or connection to that apartment? Is that correct?
Yes.
All right, and so it is dated over 2 months before the date of the search. Am I correct about that?
Yes, Your Honor.
And it's just for a tablet,
Yes.
right? Okay, and the tablet, there's no evidence that the tablet was there when they.
Very limited evidence in this case,
Okay.
Your Honor.
All right, so what's the theory that the evidence, the Commonwealth's theory that the evidence was sufficient to establish that on that day when the drugs were found, this defendant resided at that apartment?
I would suggest the evidence the Commonwealth argued was that he was found right outside the apartment when the warrant was executed, although probably shouldn't have made it in. The officer testified that they had a search warrant for this particular residence, and this defendant was named in that search warrant.
There were 3 people, right, there were 3 people named. I don't know who the third person is.
Yes, the third person, I think,
So is the theory that all 3 lived there? I don't know. I mean, it's a theory is not evidence, so maybe
Yes.
we can just stick to the evidence. So the evidence
That there
that
was-
he lived there is this document.
Yes. Which, to answer your questions, the cases the Commonwealth found were bills and like cable and telephone bills. It's a Riviera case, but no date on them.
Right, which were for the place the bill was
Yes,
for.
bill, yes.
This is, I mean, we
I
can recognize
appreciate-
this is different. This, it's like just if this were a store receipt, that he had bought the tablet outright,
Yes. That wouldn't be, I wouldn't,
it wouldn't be
That-
enough,
no.
right? So I guess the question is, because it's a lease?
least, which he would have to tell them what's your residence, and he would have to have said, my residence is the name, I'm blinking on the residence
So
right now.
what do you think is the closest case on the facts for the Commonwealth?
This is a very tough case for the Commonwealth, I recognize that, Your Honor. Commonwealth v. Riviera, 31 Mass. Ave. 554, but I think, I appreciate you could probably distinguish between that and
Which
ours.
case?
Commonwealth v. Riviera, 31 Mass. Ave. Court 554, it's a 1991 case, and the drugs were found in a closet, and they found the defendant's personal belongings in proximity to the drugs was enough to support constructive possession. I get that the documents there are different than the documents here. Again, in the light most favorable Commonwealth, an extremely close case with the facts we have, I appreciate this court's concern, but we would suggest that with the defendant being seized outside, being named in the search warrant, and the fact that he started to run when the police
The
arrived,
search warrant boy, I really wish that we'd had the evidence that was in the warrant affidavit that indicates that they should be able to search that home and that person, but none of it was put in by the Commonwealth, right?
Nope, it was not, Your Honor.
I mean, I presume that's maybe informant information, but
I would assume it was controlled by, I don't know, we don't have it.
But we don't know,
But the
'cause it wasn't
typical
in.
search warrant,
Can I
I
ask
would
you-
assume that's why it's not in.
can I ask you, you put in flight.
Yes. I know. I
Okay.
appreciate,
Are
I
you
appreciate
standing on
this.
flight, or is it really, I mean, it took two, he
said he
saw
started to run
6 or
and
7
then
guys
stopped.
running, plainclothes guys running at the apartment. They started to run 2 steps, stop, they stop, they can, okay. So we're not, so flight's probably not your best argument.
Have we ever said that being listed on a search warrant was sufficient for purposes at trial to establish residence?
Not that I could find, Your Honor.
Okay.
Do you see any difference, same question, between between drugs being found inside a VCR versus inside a desk drawer or a bureau drawer?
Just a little bit, because inside a VCR is a peculiar place to place your drugs, while inside a desk drawer, you would have more, it's more usable, someone's more apt to possess what's in a desk drawer. If you're hiding it inside a VCR, you're really trying to hide the drugs.
And in Clark, that was a common area, at least that's what the
Yes,
court found, common area versus here. Your argument is one occupied bedroom, he's an occupant,
yes.
so he occupied it. And what about the defendant's contention that to whatever extent there was some vacillation as to whether the drugs are found in that bedroom as opposed to somewhere else, how do you
My
consider that?
recollection of the record, and I don't have the trial transcripts in front of me, but I have cited in my brief, trial volume 1 at 200 to 201, 203, and 220, the officer testified they were found in the used bedroom. Any unsurety in closing, in his cross-examination, I don't think he said, no, it wasn't there. I believe he may have wavered a bit. When looking at sufficient of the evidence, you look at it in light most favorable. So while it could have hurt his credibility, I don't think it diminishes the fact that he did say that was one used bedroom and one unused bedroom.
You
with the drugs.
established that there was only one person in the house, and it was him. He lived there, and it was in the bedroom. You would say that's enough for sure, right?
Yes.
Okay.
If there's no further questions, the Commonwealth will rest on its brief.
No, thank
Thank
you
you.
very much. Thank you both for your argument, and the case is submitted. The next case is Commonwealth versus James Cody, number 2022P1095. Attorney Burkholder,
Good morning, Your Honors.
we're ready whenever you are, but take a moment to settle down.
Okay. I know the court has read our briefs. I think that they sufficiently set forth the facts that have occurred in this case. Certainly, there's a terrible history of continued sexual misconduct. What I find interesting in the case, and what I tried to convey in my brief, is this. 2006, he gets found not SDP. Then he goes out and he commits 2 offenses. And he comes back into, and prior to 2006, he had not engaged in any treatment, and he was a younger man. He comes back into treatment, quote unquote, from Dr. Kriegman, he's scared straight, he gets involved in treatment, and most importantly, since March of 2019, he does nothing else wrong, which is completely out of character for this guy, given his record and the amount of disciplinary violations he's had and sexual misconduct violations he's had and the like. So why is it important to me?
Can you just say that again? What years, during what period do you say? Is that?
2019.
From when until?
From, well, after March of 2019, he gets involved in only one D report, I stand corrected, and that was for, he says, defensive assault and battery, but no sexual connotations.
When was trial? 21, right?
Again, please?
When was trial? 21?
Yes. Trial was August, I'm sorry, I wrote it down. Oh, here it is. Let's see. Trial was October 15th, 21st through 20th.
Yeah, in 2021.
That's correct.
And the petition, though, was filed in January of 2020. I think January 3rd.
Good thing I brought my brief.
I think so, January 3rd, 2020.
January 3rd, 20,
Yeah.
in Berkshire.
So, you would say he was offense-free from 2019. Any particular date in 2019?
March of 2019, I don't know if I have the exact date.
Okay, so the
I might.
petition was filed, like half a year later. So is it the passage of time that you're relying on?
Well, yes, but let me preface by saying this much. Because this was a COVID-related case, it sat for a while.
And because it's COVID-related, he's isolated, right?
Again, please?
He's isolated? I mean, during COVID,
Well,
they didn't
he
have
was
the ability
placed
to
in
interact, and
certainly he
plus
was
he's in a
placed
place
in
where
a
he's...
temporary setting, which on state
is he-
side is
right.
different than, yeah.
He's locked down, what, 22 a day? 22 hours a day?
I don't know the numbers, but you're probably right. Most importantly, the setting is different. It's not dormitory, it's more cell, 2 people and the like. By the time the case comes to trial and the reports are updated, it's now been about 2 years rather than 6 months. Is that a lot of time? No, it isn't. But it is some time. And when you're talking about progression from age 65 to 67, I think Dr. Kriegman hits it on the nail, and I think Dr. Peretti agrees with it, and that's this. Under Static 99, as this court well knows, there's a cap at age for the credit of 3 points at age 60. And Dr. Peretti even admits that that's the maximum protective factor. So I could be standing here, and I think I've made that argument to one, if not one of the members of this panel, more than one, which says, well, what happens when you're 75?
Yeah,
Are you still going to tell me that?
And it's an understandable argument, okay? Here's the problem with that. I think the way the system is set up, they depend on the qualified examiners to examine the SDP, the accused SDP, and decide whether, those extra years make a difference, right? I mean, you're saying, look, at some point, you're saying he's not going to be a risk anymore. That's your... right? But isn't the system set up for the QEs to evaluate that? And these QEs evaluated that, and they said he's still SDP.
Yes, but, and here's the but. I think there's two different means in which they're evaluated. Excuse me. First of all, they have to look and determine whether or not he has a mental abnormality. Let's take apart the antisocial personality disorder, and let's put that aside, not talk about it for a moment. Let's talk about the mental abnormality. To have a paraphilic disorder, you have to have 2 things. You have to have the interest, and then you have to have action upon the interest. And what Kriegman is saying, and you'll read the reports, says, although admittedly he's had that interest going forward, since 2019, he's not acted upon it, so there's been no consequences of it, hence there's no disorder.
I want to make sure that I understand the legal framework in which we are to assess your argument.
Okay.
I took it from your brief that you were raising an argument regarding the sufficiency of the evidence.
Basically, yes, I argue
Yes.
in 2 different capacities.
Okay,
I argue
so
it first,
if
directed
we-
verdict, and then,
Okay, so basically, you're arguing there was insufficient evidence upon which to find that this person had a mental abnormality or personality disorder, correct?
Correct.
And in assessing that argument, we take the evidence in what light?
in the best light for the Commonwealth. without
Okay,
any
so it
question.
doesn't really matter what the defendant's expert said when we're in that framework. We just take the evidence that's in the light most favorable to the Commonwealth, correct?
Certainly, but.
Okay, so it helps, at least for me, because ultimately, when we go to decide this case, we have to stay within the legal framework that we're given. So it would help me if you could stay within that framework when you're making your argument. So within that framework, why was the evidence insufficient on the record we have here?
Because I think the experts did not properly consider the existence of action upon his paraphilia that constitute a perfect disorder. And I think that's what came out through cross-examination, and I can probably try to find it if you wish, but the point is that counsel was trying to point out, listen.
So
don't
you're
you
saying
need-
they
Don't you need
couldn't,
both of these to get to a mental abnormality? And they admit that.
so you're saying, I take it, that the jury could not accept the Commonwealth's witnesses' expert testimony?
No, I think that if they properly look at what the expert's testimony was in its entirety, whereby they admit that, yes, there has to be both an action upon that interest, I think if they look at it in its entirety, and the judge looks at it and says, if they do look at it in that capacity, and they take age out, and they don't just consider it under static 99, I don't think there's enough. Look, it happened in Sousa, and it happened in this guy before.
Sorry, counsel?
Yes, I'm sorry.
Did both qualified experts testify at trial?
They did.
Both of them gave the opinion that he had an existing mental abnormality.
They did.
Both of them gave the opinion that he also had a personality disorder.
They did.
Okay. So to follow up on what Judge Wolohojian is saying, I think you have to be arguing, in essence, that testimony should have been excluded in order to win an insufficiency of the evidence argument, don't you?
Or that the evidence, their opinion was somehow legally deficient and couldn't be relied upon?
I understand the conclusion. I mean, that was the conclusion that happened, and I think it maybe it was Page, whereby there was no expert that actually came forward and said, and it's pointed out by my sister in her brief, that there was no expert that actually came forward and said sexually dangerous, and as a result, under Johnstone, it had to be reversed, and it did. And that occurred. It's going to sound like I'm sidestepping, but I don't think I am. If you read through the balance of my brief, I don't think I just stick to directed verdict, nor does I think my sister view it as such, because she argues whether or not it was beyond a reasonable doubt. And I think I do too as well.
Right, you're arguing that the evidence was insufficient.
Yes, both as at a directed verdict.
It doesn't matter which posture, because if it all reduces to the same standard of review for us.
Well, but I think it does make a difference in the essence that if you're just looking at the two QEs and you have to take those in the most favorable light, then I understand there's a much stronger argument.
Was there
But
even a Daubert motion on the two QEs?
Not to my knowledge. I brought that along, and no. There was restrictions with regards to testimony concerning prior experts' opinions, and there was exclusions with regard to treatment, but I don't believe there was a Daubert motion. I
Can I
brought it
ask-
along
wait,
just
I'm
to
sorry.
glance at it.
When you say you argue beyond reasonable doubt, just so we're clear, and I think Justice Wolohojian alluded to it, the standard is whether any rational juror, taking the evidence in the light most favorable to the Commonwealth, could find the elements beyond a reasonable doubt, right?
Certainly.
So, I mean, the beyond reasonable doubt is the tag, certainly an important part, but we can't ignore the first part. And then the second question I have is, and I'm circling back, part of, or it seems to me your argument is that because he did not act out for that span of time from 2019 on, and again, I'm looking at your client's testimony, which is at volume 5, page 90, and he says he spent 20 hours a day in his cell by himself. And then when he goes to the shower, he is individual, one person, by himself. So why could any juror not, or fact finder not assess that and say, well, okay, the fact they didn't act on any impulses really doesn't have a lot of meaning if he's in a room by himself?
May I ask a question?
No, you can answer mine.
You know where I'm going.
You can answer my question.
Because if you're going to be in the same capacity, in the same setting, and you're going to be locked down for 20 to 22 hours, and you're limited in your and there's only 2 people in the cell, and there's no opportunity to observe others and, disrobed or otherwise, then when am I going to get there? And I think that's where really my argument in the whole case goes, which is this. At what point is the lack of participation in and of itself in treatment? Even the experts say lack of participation is not risk indicated, it's not risk increasing. Certainly participation is risk decreasing, but lack of participation is not. So at some point, these guys, and there are many of them that sit out there that are 75 years old that sit in their cells and don't do anything, and they're restricted in that capacity.
Wait, the evidence, the experts say, they don't say it's not risk increasing. They say we don't have a correlation between a lack of participation in sex offender treatment and increased risk. Isn't that what they testify to, if they say that at all?
Let me see, this is from my sister's brief, lack of treatment is not a risk increaser. That's from my sister's brief.
That's very odd, because I could swear I've seen, I don't know how many cases where the lack of treatment is considered as part of a risk-increasing factor.
Without
For
any
purposes of,
question.
For example, for purposes of whether they're level 2 or level 3 or level 1 on SORB cases.
Without any question.
Okay, so that's very odd to me.
Without any question, and there's even a case named Wyatt, which maybe one of you sat on that panel, I don't remember who the judges were. The whole argument was whether or not what treatment consisted of out there and the like. And that's what the litany of cases from Page and Hill and the like all looked to determine, and Sousa subsequently and Lesage after that is, at what point does lack of treatment mean anything?
When did he go into lockdown? When COVID hit in 2020?
Yeah, well, he went into lockdown when he was transferred in 2019, probably very close to the same time, when he
Well, no, there's a
when he
year
became a
between
detainee.
March of 19 and COVID. There's a year, and I was wondering whether he wasn't in lockdown for a year, but he
Well,
was.
I can tell you exactly, because it's the date he became, probable cause was determined. And probable cause was determined on, let's see, probable cause was determined on March 30th, 2020.
Oh, 2020.
Yep, that's what it says.
Okay, all right. So there was a year when he wasn't in lockdown, when he has nothing on his record. Okay.
Which for this guy, he's been in custody. He's not only just been at MTC.
This is not, I'm not sure this is saying what you think it is, sir. Yeah. The fact that he got 1 year, I'm not sure that's as good as you think it might be.
Well, this is better than nothing.
I'll agree with
You're
that.
sitting in my shoes. If the court has nothing further, I stand on my brief.
Let me see. No, thank you very much.
Thank you.
Attorney McGrath?
Good morning, Your Honors. Jocelyn McGrath for the Commonwealth. As a preliminary matter, I need to ask your leave to make a factual error correction. On my page 16 of my brief, I stated that the March 2009 oral rape of Jason occurred in the North Adams Williamstown Library. It actually occurred in the public library. So that is a
I
significant-
wondered about how all of these things happened in the same college library, or so many of them. It struck me as odd.
Thank you, Your Honor, for your understanding. As you pointed out, my brother has made a sufficiency argument, and our Commonwealth's position is there's overwhelming evidence on the standard that Mr. Cody continued to be a sexually dangerous person. This creates a kind of cognitive dissonance, in my opinion. I would just like to add one thing that you pointed out, that I think the QEs for the Commonwealth said that a lack of successful treatment is not protective. Was that what you were going for?
Is not.
Protective. It doesn't provide protection. So
I don't understand what that means.
in terms of risk, if the lack of successful treatment would provide a risk protection, but the lack of successful treatment, it's
That's consistent with the notion that a lack of treatment is a risk-increasing factor.
It's actually, it's how the standard works is that it basically, it describes the abnormality, it describes the sort of dynamic factors and the kind of personality disorders. And then it goes towards what are the risks, the static risks, dynamic factors that are risks, and then it says what are the protective factors on the far end. So I think that's the sequence. So I think I'm only trying to understand the argument because I didn't actually develop this in the brief.
Look, I might have this wrong, but I think and I thought I saw this in the briefs as well, I think what your brother is saying is the lack of completing sex offender treatment should not be considered as a risk-elevating factor with respect to someone in an SDP case. And that strikes me as inconsistent with a lot of argument and a lot of briefs that I've read over the last several years. But I thought that you had, or so I thought that was essentially uncontested in the briefs.
I understand, Your Honor.
Is it contested in, I mean,
Oh, no, I don't believe so. I don't think it was framed that way. I don't think it was framed like the lack of
that just seems very odd to me.
If you would like me to go to my brief and clarify it and send in a letter, I could, if it's that important.
No, that's all right,
Okay.
thanks.
Can you talk a little bit about the static 99 and 60 years old?
Absolutely, Your Honor. I think what's really interesting is that I went back to the two cases that I had cited, sort of Sousa, which I took the framework, the legal framework from, and in the Sage. And I noticed that they didn't, even though it had been revised, the static R had been revised, the 99, they didn't use it. This is actually a case where they're using the revised instrument, which basically does have at 60, if someone is released, they actually have a 5-year period where the actuarial period would apply. So even though they say the cutoff is 60, it actually really goes in an actuarial sense to 65.
Don't understand that. No, this is what let's try to get on the same page, or at least help me get on the page. What I understand is that in the static, there's a number assigned to various events, prior events for this particular person, but you subtract 3 if the person is over 60. Right? So this,
good,
I
yes.
think in this case, the person was assigned to 6, right? The petitioner was assigned to 6. And that means he got to 9, and then we took away 3. But we can't take away any more than 3. If he's 90 years old, we're only going to take away 3. Is that the way it works?
Essentially, yes, Your Honor. That
Okay.
is the way it works.
All right.
And I
Does
think
that make sense?
absolutely, because we're talking, I mean, if we do accept the fact that, which was really extraordinary, that we revised this instrument to be able to take into account the fact that aging does reduce sexual recidivism. And then really what happens is that, so
I don't understand. So if you revise it, but you revise it incorrectly, that doesn't matter?
Oh, Your Honor, it wasn't revised incorrectly.
Okay, well, that's the question that I think it's really the heart of the question here, which is there's just a reduction at risk at the magic age of 60, and that that risk never decreases further regardless of how much longer the person lives?
Your Honor,
And what would be the scientific basis for that proposition?
the scientific basis is that this is, it's a baseline, and it needs to be considered in concert with the dynamic factors. It is
But it
not
also needs to be rational. It's not rational to me if the person is 85 to say the reduction is the same as if the person is 60. Now, that's Judge Wolohojian's question. My rationality may be wrong, so she says, what's the scientific basis for no further reduction as the person ages?
I think you're framing it no scientific basis, but there's a huge scientific basis for the instrument as it exists. And what I find really remarkable is they took into consideration the huge data, the research, and they revised this instrument to be able to account for the fact that at a certain point, and they chose a point, 60, and then the window goes 60 to 65.
Did they consider and reject the notion that risk doesn't further decrease after age 60?
Absolutely not, but at that point.
Okay, so then, and where would we find that information? Where would we find what information they considered to reach the conclusion that only a reduction at the age of 60 is appropriate? And that no further reduction, regardless of how old the person becomes, is called for?
They wouldn't have put it that way. They would only say this is a baseline. With the dynamic factors and the protective factors, you could go actually underneath the baseline. You could actually have a person who, on the actuarial model, the statistical model, is a 6. but through the dynamic factors, actually presents less risk.
So you're saying the further aging would become a dynamic factor?
Absolutely.
Where in the process?
It would actually be something that we would have to, that the experts would have to opine on. And my understanding is because there isn't a huge body of research done, because that population is actually smaller. The over 60 population, for whatever reason, I'm a layperson, they chose that as a threshold. They chose it as a threshold for statistical
He's
reasons.
70 years old now, right?
And for him, his dynamic factors are so strong. They're so extraordinarily strong, and they were on display in front of the judge and jury, that his distorted thinking in terms of Jason actually, he tried to relitigate the last oral rape, basically in front of the judge and jury. He tried to say that, he said he was 17. It was consensual. I asked him, how am I going to know if people want to have sex with me if I don't ask? These are the distortions that actually the QEs pointed out. This is what makes him still a sexually dangerous person, is his actual perception, his lack of insight to how
He still may be a sexually dangerous person, and at the same time, the theory as to how the government is handling the reduction in risk associated with age may also be incorrect. Those two things can simultaneously be true.
I agree with you, Your Honor.
Okay, so what we're trying to get at is the latter, not all the other evidence, but just to make sure that the increase in age is accounted for appropriately.
I agree.
Some basis for, I mean, it needs to be tied to whatever scientific basis there is for this entire system.
So part of why age would reduce a person's proclivity would be, some of it has to do with health conditions. So what the experts, all the experts say, is that they're too closely correlated to be able to separate them out, but because the statistical model now incorporates age, it sort of incorporates specific health conditions. But I would say that health conditions would be a factor that could be separated out with age.
Understanding that it's not an issue in this case, do you know when the last time the static 99R was tested through a Daubert-Lanigan hearing?
I do not, Your Honor.
Has it ever been?
I'm
Challenged?
not aware. That's an interesting question. I don't know.
My memory is reading something that it was, and I think that's why we got 99R, because we had a problem with 99. That's my memory, but I could be wrong. The sort of, for the benefit of sort of your thinking, here's a thought. The argument that comes from the notion that you only reduce at age 60 is that this person's static is going to remain consistent through his death. And this person, of course, is not sentenced pursuant to any criminal law. This person is there because they're determined to be civilly committed. And there has to be a good reason to keep people in jail forever. So that's why I think we ask these questions. All right? Mm-hmm. There has to be something, some rational, one would think there's an end point to someone being a sexually dangerous person that occurs before age 90. That's just my sort of general thought.
Mm. What's interesting is this is not that case. This is a case with
I understand it's not that case, but it is part that case. He's 70 now. And yet there's no further reduction for the next 10 years.
Respectfully, Your Honor, I think that we still take these case by case. So here's an example of someone whose preferred sexual transgression is oral sex. So in a sense, he's arguing that I physically cannot get an erection and I cannot have an orgasm, but his actual activity does not require his physical capacity. So I think, really, even though you're saying, I understand, it is uncomfortable. This is the reason why we're here. It is uncomfortable. But I think that we still take it case by case, and in this case, the way he offended and the lack of insight, which was really extraordinarily available to everyone at trial. Also, the lack of an exit plan. His transition plan was remarkably weak. I mean, no friends, not planning to do treatment. He wanted to leave the state. He was going to go in a homeless shelter. I mean, he really, you could have compassion for this person, but really the part of the issue here is that where should he live? You know, where should he live? And that is not actually something that we can solve here. I appreciate your concern, and I share your concern.
Do you have any more questions? I don't see any further questions. I think we understand your argument. Do you have anything further you'd like to add?
No, Your Honor, I feel very grateful to have been able to have this conversation with you.
All right. Well, thank you both. It's an interesting case, and we've been benefited by your briefs and your arguments, and the case is submitted.
Thank you.
The next case is Commonwealth versus Dos Santos, 2022P 1125. And as a reminder for those of you who are planning ahead, we're going to take a 10 to 15-minute recess after this case. Is it Attorney Sullivan Puccini?
Yes.
May it please the court. Sharon Sullivan Puccini on behalf of Mr. Dos Santos, the defendant. This case involves an incident between Brockton police officers and Mr. Dos Santos that occurred during a child exchange between Mr. Dos Santos and his wife at the time, who they were separated, to pick up their children. One of the children, the baby, had been sick, had been at Children's Hospital overnight, and Mr. Dos Santos was following the doctor's orders and didn't want the child to be in the cold, so did not turn the child over to his ex-wife. What ended up happening was Mrs. Dos Santos comes back with a police officer, Officer Ford. This case basically comes down to the credibility of the police officers and Mr. Dos Santos and his mother, which was he testified on his own behalf, and his mother also testified. Basically, the jury had to decide which version to believe. And in this case, the charges were actually against the officers. So we had 2 counts of assault and battery against a police officer, resisting arrest, assault and battery with a dangerous weapon. So the way I've argued my brief is that all 3 issues, the cumulative effect of the errors by the prosecutor for the first 2 led to a substantial risk of a miscarriage of justice. So for the first issue, when the defendant is testifying on cross-examination, some of the questions, and I've articulated them in my brief, on cross, sought to have the defendant assess the credibility of the other officers.
So I'd like to ask you about that.
Sure.
Because when I went to look at the portions where you were citing in the transcript, it didn't look to me as though those questions were designed to elicit views about the officer's testimony, but actually were targeting, let's just call it, implausibilities in the defendant's version of events. So I'd like you to point to me to the specific questions you're asking.
So the first one is when he asks, I'll just give you the little background before he makes the
Which
question.
volume are you in?
This would be 2. So, yeah, volume 2.
Which
Page
page of volume
36,
2?
235.
35?
235. So specifically when he's asking him about what he was saying to his wife and the defendant, now the defendant's explaining what happened, and then the ADA
It's helpful
says-
to look at the actual testimony and the actual question.
Yep, so, all right, so I'm going to read the question. Isn't it true you said, F you, this is America, I ain't doing nothing? Isn't that true? Isn't that more accurate?
That's line 19, right?
Yeah.
Okay, yeah. Yeah, I don't have
Or
my,
20.
yeah.
Okay.
So that is, he's basically saying what Officer Ford said and saying, that's what you said,
Why is that impermissible?
because,
Do you have a case?
so the case, yeah, so what he's doing with his questions, in the specific ones that I've outlined, not every question, but he's tempting him, and that's Kynes, and the case that I like, although is Long, and in Long, there were multiple.
I honestly do not understand, and I'm sorry to say that
That's
way.
okay.
I don't see any solicitation of an opinion in this question on the veracity of the police officer.
Because what he's basically saying is, didn't you say this, which is what the police officer said in
No,
his
he's saying,
testimony.
isn't it true that you said this? And then he said, no. And then
he said,
that's
no,
it.
that's not true, that's not true. So basically,
Yes.
he's saying, what the officer said
He's-
is not true.
He's not
lying.
asking him to opine on what the officer said. The prosecutor is highlighting a contradiction in testimony between the defendant's version of what happened and the officer's version of what happened. How is that impermissible?
Because the way he's doing it is argumentative, and Long talks about that.
Not
Specific.
argumentative. Didn't this happen? The question is not argumentative. How else are you going to highlight a dispute in the testimony? The officer testifies, this is what happened. Then the defendant testifies, this is what happened. When the defendant testifies, he doesn't say the same thing the officer does. So now on cross-examination, how else are you going to highlight the fact that you're saying something different than what the officer did? And isn't that exactly what cross-examination is for?
But he's not asking him to explain.
He does.
It's not his job, he's cross-examining.
But that is what the cases say.
Let me ask
The
you a
cases
question.
say they have to be given the opportunity to explain. They can't just,
If defense counsel had asked the defendant on direct examination, did you say, F you, this is America, I ain't doing nothing? Wouldn't that have been a permissible question?
if his own attorney had asked.
Had said, did you say, F you, this is America, I ain't
But it's-
doing nothing? Please answer my question.
Yeah, I think so. I
That
think
would have been
might
a permissible
okay.
question. So
But-
the fact that the prosecutor on cross-examination is saying, isn't it true you said, you think that's impermissible cross-examination?
Yes.
All right, what is your best case for that?
I would say Long and Ward.
Long and Ward?
Yes, Long, I think in my brief, it's Long citing Ward, because they have to, as long as they're not asking them to assess the credibility. And I see it as, he's basically asking him, he's tempting him to say, is what Kynes says, when he gives him that, this is what the police officer said, he's lying. He doesn't say that. Now, granted, I'm going to say to you, yes, these cases, usually the officer's saying, usually the prosecutor's saying something like, so you're saying Officer Ford's lying. We don't have that.
That's a big distinction.
So
It
let me give you a
is.
simple example. The police officer says, I saw the defendant drive through a red light. And then the defendant takes a stand and the prosecutor says, are you saying it was a green light? That's impermissible?
When it's,
Just on those facts. So the officer had already testified, I saw him drive through a red light. And then your client takes a stand, and the prosecutor says, are you telling this jury that you drove through a green light? Is that permissible?
that would be different, because
Isn't it true that you drove through a red light? No. What's the difference?
the difference is he's using the words specifically of what the defendant said by using the words of what the officer said. And it's, what it's different, and I want to answer your question, Justice Walken. what's different from being the defendant versus the prosecutor, because the prosecution, and that's what these cases are talking about. It's the prosecution. It's coming from the government. These officers have prestige. And the difference between, the charges that he has, these are against the officers. These charges are against the officers. So it's not just, it's my word against yours.
That usually
and
doesn't
his-
bear on the on whether a particular form of questioning is proper.
But when it's the credibility that the jury's to decide, that's up to them.
All right, let's assume that we were to conclude that these questions were designed to probe your client's credibility, not to ask your client to opine on the officer's credibility. So let's just assume, I'm not asking you to concede, let's just assume that that's what we were to conclude. What next in terms of your argument?
I think it would be okay to probe the defendants, but not have him, the whole point is to have him.
No,
assess the
I'm
credibility.
basically saying, and I'm sorry it was unclear, let's assume that we disagree with your view of the questioning.
You have 3 points, right?
You have another point you want to argue, or any other points you want to argue
For this first argument,
for the case,
for the case. Closing argument.
closing
Yes.
argument?
So, closing argument, and that turns again, because we're going back to credibility, right? So this is important, having to do with assessing credibility and what the
What's your
officer
best
said.
argument for what was inappropriate in the prosecutor's closing argument? Which one do you want to point us to first?
Okay, so the first one was, so the first one I argued in my brief, the defendant's mother, so 265 of the transcript. Defendant's mother was living with them, they both kind of share the same story respectfully, doesn't make sense. I mean, you have uniformed police officers, veterans on the force, midday, full uniform. I mean, the defendant knew it was a police officer, and these people are going to risk their livelihood by punching the defendant in the nose with absolutely no provocation?
So
Does
what's
that make
wrong with
any
that
sense?
argument? What's wrong with that argument?
So when the prosecutor is arguing, he needs to point to specific evidence of why that's wrong. And he's saying it's implausible because police officers wouldn't do that. And the defense is self-defense. So also, it's improper because what the prosecutor is doing is he's saying that it's impermissible for defense counsel to question the credibility of the police officers, and that's Grandison.
No, he doesn't say that. He's making an argument which the jury is free to accept or reject to the effect that, do you believe that knowing what you know about human nature, people who are uniformed, police officers, do you believe that they just hauled off and punched this guy in the face midday with witnesses around? And your argument, I think, is he wasn't allowed to argue that.
He has to point to evidence, specific evidence.
Yes, he's pointing to the fact that the time of day, what they were wearing, which, by the way, what they were wearing had to come in because it's a resisting arrest case, and so he has to show that the defendant was aware that he was dealing with a police officer, so that evidence has to come in. Those are facts. He's arguing from facts, and then he's asking the jury to draw whatever inference a jury might draw from its common understanding.
But he's saying they're coming in here and risking their livelihood. Later on, in another portion, he talks about,
Maybe, okay, so
But again, do we not give jurors any credit whatsoever for being able? Some jurors might say, yeah, you know what? I buy it. He was so mad that he didn't even think about his livelihood, so he just hauled off and punched the guy, as the defendant claimed he did. And other jurors might say, no, why in a million years in broad daylight and in uniform would they just with no provocation punch someone? I mean, isn't that the trial dynamic? Isn't that what this is all about, to give an argument? It just seems to me that if we follow your path, we're going to have the most sterile trials with robotic jurors who don't listen to anything
No, but it's okay
that's
for that.
persuasive.
Specifically, they can say that one side is lying, but they have to point to the evidence. And what he's
Actually, I
pointing...
don't think you can say someone's lying. I think you can identify specific, well, go ahead.
You
Sorry to
can't
interrupt.
say... You can't say...
Justice Brennan, I may not see this
lying.
exactly the same way.
But you can't say, you can say someone's lying. I mean, I have cases in...
I think what
the AJ
Justice,
I mean,
I think
liar,
what
sorry.
Justice Brennan is actually trying to get at is even assuming that the statement about the risking livelihood steps over a line, where is the prejudice? In other words, how is it in the totality of what we've got here, because it's an unpreserved
Correct.
error, assuming it's an error, that misstatement would warrant reversal? And I think what Justice Brennan was trying to get at was, we know from the verdict that whatever else can be said, the jurors did not come away with like a wholesale brush of tar against the officers, because they acquitted the defendant of some of the charges against
Correct.
of assaulting the officers. So perhaps you could address that?
Sure. Because not only was he doing that, he's disparaging the self-defense argument. And also, it's not proper to say they're just because the police come in here. And that's the thrust of his argument. He's basically, later on, I argue about him just coming, the police officer just coming in, and the prosecution argues in their brief, well, the other witnesses came in, but they're not on the same footing. A police officer has a prestige of the government, and they're an agent of the government. And just, the theme of his argument was, they came in, they told the truth, and you should believe them. You should believe them because they're police officers. I think that's the point of his argument, and hopefully I got across to you. Coupled with...
I think we have your argument, and we'll have
All
to
right,
leave it there.
and I will rest on my brief.
Thank you very much. Attorney Black?
Good morning. May it please the court, Johanna Black on behalf of the Commonwealth. I think I just want to touch on two quick points with respect to the prosecutor's closing argument issue, and then just open it up for questions if any of your honors would like to ask the Commonwealth any. So just briefly, I think the Commonwealth, it would rest with respect to the closing argument issues on its brief, but just to additionally point out how the prosecutor's closing in this case, in the defendant's case, was so unlike the prosecutor's closings in McCoy and Shelley that the defense cites in their brief, especially
I know,
where
but we're not usually measuring closings against an absolute floor. We're still idealistic enough to think that prosecutors should be aiming for a higher bar.
the best conduct possible.
Right, a higher bar.
I
And
understand.
I'm curious, because I do think that asking the jurors to assess credibility based on whether the officers, sort of like saying, would people lie if they came into court? Or, would they risk their livelihoods? It's inviting a form of speculation about motivation that I don't think is really appropriate for the prosecutor to do. Have we blessed a statement of this sort in closing argument?
So the portion of when the prosecutor is referring to what is left in the evidence for the jurors to consider.
No, the
and he
one
says
about the
officers-
livelihood.
Well, you mentioned came in and testified, and I just want to say
I know, that was
Commonwealth
just an
doesn't.
analogy. This is just, and these people are going to risk their livelihoods by punching the defendant in the nose with absolutely no provocation. The reference to, would people risk their livelihood to come in and lie in
Right.
court? Have we ever blessed a statement like that in closing argument?
Well, I can't think of a specific case off the top of my head. However, in closing arguments, prosecutors are entitled to forcefully argue for convictions, and just like any other witness, for example, a defense expert witness who's being paid and that's in evidence, and the amount of fees are are in evidence, the prosecutor's entitled to use that as to some motive to testify a certain way. Similarly, a police officer who spent this many years on the force, that could be a motive to testify accurately, doesn't want to jeopardize his career. Just like where the prosecutor may be arguing against a defense witness or for a Commonwealth expert witness. These are reasons why you should credit the testimony because, for example, I'm just going back to if a prosecutor is trying to challenge a defense expert witness, they can use the livelihood of that expert witness to,
It's an
on the flip
expert
side.
witness.
Right.
Right, but we're talking here about a lay witness.
So for a lay witness, a civilian witness, if a
And do you have,
civilian witness
I guess I still
testified-
haven't heard a case cite, which is what I was
I think
looking
of one off the
for.
top of my head, just in practice as a trial attorney and on
Commonwealth
appeals.
concede that the statement, and he's going to come in here and risk his livelihood, does the Commonwealth concede that that was incorrect?
The Commonwealth concedes that if the prosecutor were to argue based on the fact that the officer came in and testified that he should be believed, that would not be a proper factor to argue for the jury to consider in terms of credibility.
This
However,
risk
it's
your
not.
livelihood doesn't really go to the fact that he came in to testify. The risk your livelihood goes to the notion that the act was committed in broad daylight with witnesses present.
That's correct. The
Right?
Commonwealth sees it as two separate factors, and one, the came in and testified, is not a good factor to argue for credibility, but the other factor, the fact that based on the evidence, the officer's aware that these people see him as a police officer, and he's been doing this job for this many years.
Can I follow up on that, actually? Because it seems interesting, that this was tried in January of 14. I think the Eric Garner case out in Staten Island happened in July of 14. So it was before that and the whole I can't breathe and all the protests, and Black Lives Matter, et cetera, right? So do you think that if that argument is fair, it's fair for a defense attorney to stand up and say, well, clearly we know that police officers don't care whether what their livelihood is at stake or not. They're just going to do what they want to do in the moment, and allude to all of that background that is not part of the actual case.
I understand Your Honor's concern.
So what's your answer?
The Commonwealth's
Do you
position
think
is
it's the other side
that
of the coin?
attorneys should stick to the evidence when
Okay.
making their closing arguments. The Commonwealth understands Your Honor's concern.
And do we have any testimony from the officers that, wow, my livelihood, this is what I do for a living, and I would never think to do that because how stupid would I be to punch someone? I'm not sure you get that in anyway, but there's nothing along those lines.
Jurors are entitled to draw reasonable inferences, and prosecutors can argue those inferences.
Well, that, I
So
think,
he doesn't
is the
have to
issue,
say
isn't it?
that.
I mean, I'm very sympathetic to what Justice Brennan said earlier, where he said, if we're not careful, we're going to put straitjackets on what can or can't be said. It seems to me that in this case, if the Commonwealth was, although the Commonwealth goes second, but if they somehow were suggesting, look, would he risk his livelihood, it would be reasonable for a defense lawyer to get up and say, look, there are situations out there and we're all aware of them.
Well, the defense
where
in
they
this
have risked their
case,
livelihood.
the defense in this case could have made the argument,
And the Commonwealth wouldn't be able to object, right? To
if
that
it's in the
argument
evidence, or
under
it's a
those
reasonable inference from the
circumstances.
evidence, of course not. But here, the defense could have elicited, how long have you two worked together with the officers, and tried to drum up some basis to make an inference that maybe Officer Ford is lying. But, it just needs to be grounded in the evidence. So, just because one officer does a bad thing doesn't mean all officers are going to, and that's why we do still need to
Okay,
stick
grounded
to.
in the evidence. And that goes back to Justice Brennan's question about livelihood and whether there was any evidence about that. Okay.
Thank you, Your Honors. There are no further questions. Commonwealth rests on its brief.
I don't see any, so with that, thank you both. Thank you
you.
both for your able briefs and arguments, and with that, the case is submitted. We're going to take a 10 to 15-minute break now. We'll be back on the bench at 11.
Floor is open. You be seated.
Okay. The following case is, I think, fully impounded. So I'd like everyone to just remember that we're not going to use any names. I personally find it most useful if we can refer to people in this kind of case by their status in the case, like not plaintiff defendant, but father, mother, child, something that we'll be able to keep track of who's who. With that, the next case is 2023 P0523, Department of Children and Families versus Father One.
Good morning. May it please the court, my name is Alan Campbell, and it's my privilege to represent Father in this appeal. In this appeal, Father is seeking a new trial in the first instance, or in the alternative, at least an order for ongoing contact with his daughter. And in this case, we have a combination of errors that leads to the ultimate conclusion that the finding of unfitness and that it was in the child's best interest to terminate Father's rights is unsupportable. And that's we have from Luke quoting Ilona, we have that this court will reverse where the findings of fact are clearly erroneous or where there is clear error of law or abuse of discretion. And in this case, we have two important facts that are clearly erroneous, and we have two errors of law as well. The first is that the judge finding that Father was represented by counsel throughout this matter. He was not.
Can I stop you there for a second?
Of course.
What do you say was his entitlement to be represented throughout?
Oh, this isn't an argument that he was entitled to counsel.
Then following that up, how was he prejudiced by not having counsel during the period of time where there was ongoing investigation and things when he was not entitled to have a lawyer?
He's prejudiced because it influenced the judge's view of the entire case. The judge viewed the case through a lens of this gentleman has been represented by counsel for the entirety of this case, and he's done nothing until recently, whereas in fact he did not have counsel.
Well, it was not nothing. It was only with respect to, as I understand it, those references were only made in connection with the father's efforts to establish paternity.
Well, it's referenced 4 times through his conclusion. He starts off in the summary mentioning it, and then 2 other times in the general conclusions, and then in one of the, the most important sometimes conclusion is where you go through the statutory factors. He mentions it again there as well. And it may primarily be in his efforts to establish paternity, but again, I would say that it's an error that tainted everything. Because when you go on to the next error, with that the DCF made reasonable efforts, again, DCF...
I'd like to see, because I always saw it in connection with the effort to establish paternity. Can you tell me point me specifically to the place where it was not connected to that?
I have the citations in front of me where it was cited. If you give me 1 minute, I can actually pull up the findings on my computer, and we could... So appendix 3, actually, unfortunately, the file I'm looking at is attached to the brief, so the pages
That's okay.
don't necessarily match up.
Yeah,
But it's appendix 31, which is probably the first page of the findings.
Do you have a paragraph number for the findings?
I do not for the first one. For the other 4, it's conclusion 4, conclusion 9, conclusion 3410, and then the fourth one is the 3410. Let me look down.
Okay, well, I think those were all in the context of...
But rather than waste all of my time searching for it, I will, if that's the case, that doesn't change my argument, because he's thinking, again, He's thinking, and there was a colloquy during the trial where he's like, didn't he have counsel the whole time? And this is something that was on the judge's mind, because he does mention, again, he mentions it 4 times in the
Counsel,
in the
not a big deal,
conclusion.
but I'm pretty sure the judge is a she. Am I wrong?
You're right, it is.
Okay, it's not that
It's my default.
really matters. No,
Let's
that's okay.
assume, okay, I think it's conceded that the statements, the finding, if you will, that the father was not represented by counsel, or was represented by counsel throughout, was wrong. And it's on his mind. Work me through why that matters to what the judge said here.
Because the judges in these cases are often looking at what has father done.
Right.
And even though the burden's always on DCF, the judges are always looking at what has the,
And here there are findings that the father was offered the opportunity to visit with the child from basically day one, right? There are findings to that effect. And
No,
the
no.
father did not do so.
for the first 2 weeks, he was offered visits. On January 14th.
That's what I said, from day one.
Yes, but on day 1 he was, but on day 20, DCF says, and there's a finding to this effect, which I've cited, you are not having visits until you establish paternity. So he
Okay.
briefly was offered visits.
Wouldn't
Not-
wouldn't that light a fire under, couldn't the judge find that that should have lit a fire under your client to take some steps to establish paternity if he wanted visitation?
Conceivably, but we have to look at the father. He's receiving SSDI payments, and he has a 3rd grade reading level. He has no attorney, and DCF is offering him no assistance. No one is offering him any assistance in establishing paternity. At no point.
How do we know that?
How do we know that?
Yeah,
Were there
There's a
some-
lack of evidence of anyone, well, he didn't have an attorney, and there's a lack of evidence that DCF did this for him, even once he
That's
has.
not the same thing as evidence that they weren't offering him anything.
Well, I believe.
If it wasn't, was it raised, whether he was, so, and this bleeds into your second argument here, that that the finding of reasonable efforts is error. Was that raised? I mean, the father chose not to testify, so clearly we don't know what he was or wasn't offered from his own testimony because he declined. So did someone say, did they say, look, there was a lack of reasonable efforts here? Was that argument
Yes,
made to the judge?
In October, the October prior to trial, it was June 22 was the trial. In October 21, once he finally had counsel that he was happy with, there was an objection filed to a permanency plan, and in it, it was specifically mentioned that father was not receiving reasonable efforts, or DCF was not making reasonable efforts.
Was it argued at the beginning of trial that DCF had not
I-
made reasonable efforts? Judge, one of the reasons that you should not terminate father's rights is because reasonable efforts were not made to reunify the family.
I don't know that that was the case, but having argued reasonable efforts in many cases, trial is not the time to raise that. If you raise it at trial, it's too late. You have to raise it before trial, which father did, 6 months or 8 months rather. Prior to trial, he raised it.
Well, if it's in some document, okay.
It is, which I cite to in my
But-
brief.
And I'll take a look. But no one is saying, you know, this is one of my arguments, Judge. This is why you shouldn't grant the relief that's sought. If that's not in a closing, an opening, or some sort of post or pre-trial filing, how does the judge even know? How does the DCF even know to put in the evidence you're claiming wasn't there?
Because in a written objection to a permanency plan, father said, DCF is not providing reasonable efforts. So DCF was on notice. Presumably the judge will have read the pleadings as well and would know that.
Wow, I got to tell you, that in most civil litigation that I'm familiar with, that wouldn't be enough to raise an issue.
It certainly would have been better if counsel had filed a motion for abuse of discretion. That's true. It would have been better. But it was presented to the court in writing prior to trial with sufficient time for DCF to act on it. And it was within
What
a
was
week or two,
the
I think.
evidence at trial concerning what efforts the father made to establish paternity?
Other than the fact that he...
After he was informed that he would need to establish paternity in order to have visits.
The record is largely silent, other than we know that father did, on his own, establish paternity.
at some point,
At some
right?
point.
So
Well, on March
but
4th.
there's no explanation for why he didn't do it sooner. And it looks like he was able to do it on his own.
He eventually, I mean, I know things outside the record, which I won't even allude to, but no, the record is silent. But we do know from,
Wasn't he waiting for the the husband/original legal father to disavow, or just holding off until that happened, partly?
there is the very unfortunate circumstance that the legal father could have resolved this very easily. He went to, I believe, the hospital to disavow his child. He didn't bring identification with him, so the hospital wouldn't allow him to do it. So that's outside of father's control. But had he done that, father would have been on the birth certificate a few weeks after.
But so he doesn't sign the surrender, the so-called legal father. But then, it's, what, 2 years, 2.5 years
Well,
before
it
your
is-
client actually signs a document saying, I'm the father?
well,
How hard was that?
Actually, I don't know what, I think it's more than just signing a document saying that you are the father. If it was,
The mother and father on March 4th signed an acknowledgement. I suppose it must have been notarized.
Right.
And then
Well-
the following day, he got counsel and away we
I think
went.
actually it was the same day he was added to the petition. But had DCF been making efforts to reunite the family, the social worker would have had that form at one of the hearings, because father was actually attending some of the court hearings earlier on. They could have signed it and walked over. The social worker could have assisted him. That would have been, in my mind, a reasonable effort. When you have somebody who's a putative father, you actually believe is
How
the
do we know that didn't happen, though? This gets back to the questions I was asking before. How do we know that didn't happen?
Well, we know it didn't happen in that they didn't sign the form and submit it, because it wasn't until March 4th, 2021.
How do we know that the social worker didn't say, I'm happy to give you a form, and father never responded to it for 2.5 years?
Well, in these cases, DCF bears the burden. There's no evidence
No, well,
presented
they
by
did,
DCF
there
that it
was
happened.
evidence. The evidence was that they told him this would need to happen.
Yes, that's not assisting somebody who's receiving SSDI. We don't know why he's receiving SSDI, but he's receiving SSDI and has a third grade reading level. Our argument is that is not reasonable. To tell somebody in that situation, this is what you need to do.
Let's accept for the moment that, that there was some basis for the delay, right? Where does that, though, take us here? Because, I mean, on what basis would we then reverse?
Well, what we know
or
is that.
vacate?
What-
Because
once-
there are so many, there's so much other evidence.
There
of-
is evidence that's not favorable to father, but it does not compel the finding that termination is in his best interest. Because what you have is once father was appointed counsel in March, and he rejected his first two attorneys, or the first two attorneys withdrew, filed motions to withdraw, which were allowed. Father is appointed his trial counsel, I believe, October of 2021. That's when the objection immediately comes in about the reasonable efforts, and father, at that point, really steps up his efforts in becoming largely compliant. There are things he didn't do. He didn't do everything, but he was largely compliant at that point. And
Counsel,
once he
can I
had-
ask, I don't know if you misspoke. When you say in his best interest, you're not talking about the father's best interest.
If I said that, it was obviously,
I mean, you're not-
the
all right.
children's best interests are always paramount in these cases. So once father has counsel, and he
So
actually.
what's the date you're saying at that point that he begins to become substantially in compliance with what's required?
Once he gets so he had a service plan, original service plan who was actually listed as a parent or caregiver with no tasks. And then he's not on the next 3 service plans. Once he actually established a paternity and has a service plan, he immediately starts working on them. I know my brother or sister are going to say that he didn't benefit from them, but a lot of what comes out is he was raised in a DCF or DSS at the time family. He does not like DCF. He does not interact well with DCF.
Right, and
But-
he's resistant to their suggestions.
He is, but what we do know is that once he was offered visits having established paternity, from that date, March 4th, until the start of trial, he did not miss a single visit with his child. He
So,
asked for addition, he was only
At
given.
that point, how old was the child? March 4th? March
The
4th,
child was, I
March
believe-
4th of which year?
It was March 4th, 2021. The
Right.
child was a little over 2 years at that point. But the visits all went well. regardless of father's inability to interact well with DCF, which I will concede, his conduct with DCF was not great. None of that happened during visits. This isn't a person who would be visiting with a child and arguing with the social worker and slamming the door and yelling at them and cursing and things. The visits all went well. That's the evidence. He interacted well with the child. He was able to direct the child. He brought supplies. And again, these cases are about the best interests of the child. The fact that father and DCF don't get along didn't impact his ability to interact properly with the child.
Why not? The father's ability to interact well with DCF bears on the father's ability to do what's required for reunification.
Yes, father worked on nearly every one of the tasks on his service plan. And what I'm saying is, he was able to show up at a DCF office, put aside his obvious hatred or disdain for DCF, and focus on his child in a positive way. You don't have to like DCF to be a fit parent. So as I got to repeat, he shows up at his visits, he interacted properly with the child, there was a social worker there presumably, he didn't have arguments or threaten or belligerent with the social worker why his child was there. So he was actually able to prioritize and say, this is my time with my child, I'm going to focus on my child and put aside the other stuff.
What about the June to September of 2022 when he failed to visit the child after there was some unpleasant interaction with the mother, apparently?
That's not great for father. It would have been better had that continued. But again, it wasn't father saying, I don't want to visit with the child. He was actually complaining, again, interacting with DCF, saying, why are the visits inside? I want more visits. I want longer visits. I want them
And
outside.
if I can't have them, I'm not going to see the child. That's what happened, right? If I can't have it the way I'm asking for it, then I will not spend time.
That's not the
with
only
child.
interpretation of what happened. That is an interpretation of what happened. We don't know what would have happened my time is up, but we don't know what would have happened the following month, because the record stops with that short window. But I see that my time is up.
Let me see if there are any further questions. No, all right, thank you. Thank you, we have your argument. Attorney, is it Braithwaite who's
Braithwaite, yes.
going to argue first? We
Yes,
have you
thank-
down as for 7.5 minutes.
That's correct. Thank you, Your Honor. Members of the panel, may it please the court. I'm Kristen Braithwaite, Assistant General Counsel for the Department of Children and Families, and I'm here today asking you to affirm the lower court's termination decree. The decision reached by the court in this matter was correct. There was abundant evidence that father was unfit and that it was in the best interest of the child that his parental rights be terminated. And the record demonstrates that father was given every opportunity to participate in this case, and it was the result of his choices and his alone that he failed to establish paternity for over 2 years. At the heart of father's appeal are his argument that he was entitled to greater supports and protections in regards to his failure to establish paternity, as well as the relationship between his failure to establish paternity and his failure to visit the child for over 2 years. Where none of these arguments were properly raised or preserved below, they should be deemed waived.
Your brother says it was raised in October of 2021 before trial.
The reality is that there are very specific ways in which these claims should be raised in abuse of discretion hearing. They should be raised in a way that provides the department a meaningful opportunity to make any corrections that are sought. But I think the record reflects even more than that. The department was making referrals, was making suggestions well before paternity was established. And so father did not actually address what about that would be inadequate. I think it was a blanket statement of insufficient efforts, and I don't think it rises to the standards laid out for us in Gregory or West about what is required if you want to challenge services.
But you're saying the statement in October is insufficient under the case law to really raise the question of reasonable efforts?
I am, but I also would say that even if addressed on its merits, the argument would fail.
Is there a legal basis for DCF's position that a biological father was not entitled to visits without first establishing paternity through a legal process?
There is. I think one thing that's important to...
What is that legal authority? A case, a statute, a regulation?
So the right to counsel was first spelled out in the Department of Public...
I didn't ask about right to counsel.
You're asking about whether the department was obligated to work with father?
To what? No, I'm asking about visitation. Is there some legal basis for the department's position that a biological father does not get visitation without establishing as a legal matter paternity first? And what is that legal authority?
I think it's very important to preface this by saying that there was confusion or lack of clarity around whether father was the biological father. It was not set in stone that he was, and I would point the court specifically to Exhibit Volume 1, pages 305.
Okay, maybe my question wasn't clear.
My apologies.
My question was about the law and whether there's any legal authority for the proposition that DCF should not give visitation to, let's just call him a putative biological father until there's a formal adjudication of paternity. Is there a case or a statute or a regulation? I'm
So
looking for
here-
a legal citation.
So here I would point the court to paternity of Cheryl, JMVCG, as well as CCVAB, which are cited in my brief, but I'm happy to give those cites if that's helpful.
And they say DCF doesn't need to give visitation unless the person has been formally adjudicated.
They discuss what the obligations are of a putative father, should that putative father want to have due process rights that are to be protected. There isn't any case law that says the department isn't required to give visits when there's no establishment, nor is there case law that says the department is required. Without the establishment of paternity, there is nothing that says the department must give visits. The department was not stopped from giving visits merely because the paternity establishment hadn't happened. There were a myriad of factors that resulted in that decision being made, but it is not the department's position that there was no authority by which it could extend visits.
And yet it looks like that's how the department conveyed the decision to the father.
Well, it was very clear, and the father even indicates that the court believed so as well, but it was very clear from the start that it was not simply a matter of failure to establish visitation. Failure to establish paternity. It was failure to establish paternity combined with father's aggressive and volatile behavior, combined with father expressing repeatedly that he did not know whether, in fact, he was the father, combined with the court investigator's report in February of 2019, and I can give a cite for that if it's helpful, wherein the court investigator, I will just tell you, that's Exhibit 1, page 29. The court investigator in February of 2019 recommended father have no visitation with the child until his volatility, lack of engagement in supportive services, and lack of proof of paternity are resolved to the point of ensuring the child's safety. So I would argue that it all along was about much more than simply paternity.
Court investigator, that was someone appointed by the judge?
Yes, it is.
That's a report. The judge appointed somebody, a report came in, and you're saying DCF was following the report.
Well, I'm not saying DCF is only following the report. I'm saying the report was consistent with DCF's conclusion, which is that this wasn't a safe environment. Part of the issue was that father was repeatedly offered various visits that became increasingly more challenging to offer. So originally it was daily, then he was too volatile to be supervised by the foster parent, so it had to come to the office. Then it was that it had to be a particular day. Father refused all of these things. At the same time, there were reports coming in about father's physical abuse of mother. There were reports coming in that father had been engaged in active drug dealing while he was denying that. There were reports coming in that...
Okay. Can I just interrupt, because I'd like you to deal with what to me is a little bit of the elephant in the room. The judge made a finding, and she said it several times, that the father was represented by counsel throughout the period where he wasn't establishing paternity, and that was wrong. What should we do about that?
You don't need to do anything because no harm resulted from this error. And here I would direct the panel to care and protection of Frank. Father was on notice since the day that the child was removed that he could not be named on the care and protection petition until he established paternity. Despite being put on that notice that his legal rights could not be addressed without the establishment of paternity, he made no effort to do so. Remand is appropriate for error only where it is impossible to say with confidence that the court would have reached the same outcome in the absence of said error. I would direct the panel to care and protection of Benjamin for that proposition. Here, evidence of father's unfitness was bountiful, and the court's finding of unfitness was in no way reliant upon when father was represented by counsel. The court found that father's unfitness was established by his aggressive, combative, and threatening behavior throughout the duration of the case, his failure to meaningfully engage in services, and demonstration of no observable change from those in which he did engage, his ongoing domestically violent relationship, his pattern of police involvement, and his unwillingness to effectuate substantial and material changes in his circumstances, demonstrating no understanding of how his domestic violence, mental health, criminal history, anger management, and lack of safe and stable housing affected the subject child. Remand is not appropriate because the court did not rely on father's appointment of counsel or lack of appointment of counsel in finding him unfit.
Let me see if there are any further questions. No, all right. I think we're going to have to leave it there. Your time is up.
Thank you, Your Honors.
Is it Attorney Shokir?
Shokire.
Shokire, sorry.
good-
I apologize.
Oh, no worries. Good morning, Your Honor. Richard Shokire for the child. May it please the court. The 5-year-old child is asking this court to affirm the orders and decrees terminating father's parental rights and freeing her for adoption. She turned 5 years old, I think, in December, and in her 5 years, father has spent less than 1 day with her. This is the issues that were before the court were of father's fitness. The evidence clearly supported that he was an unfit parent. He had ongoing criminal issues. If I can address the time when he established paternity 2 years later, after the care and protection began, he was ironically or coincidentally 2 weeks later arrested with over 28 grams of cocaine and paraphernalia for dealing drugs, including cash. Mom was present as well. During that time, I believe prior to that, he had about 15 prior incarcerations. He was domestically violent with mother. She would show up to visits with bruises. There was one incident where he would lock her in their apartment and put a refrigerator against the door so that she couldn't leave. Mother confided to the department that he controlled her with the drugs that he was apparently distributing. He was also volatile, threatening the department. My sister is correct. He did, the department from the very get-go, and I believe this was a quote in my brief, would offer him daily visits. They were working towards that. However, he wanted things done on his own terms, and he refused to engage in the preliminary services that the department was offering her. Most after his presentation, the most salient one was a psychological evaluation.
Can I ask you, sorry,
Certainly.
do you have any thoughts on Justice Wolhogen's question about what would trigger the department's obligation to work with a putative father who where there's no certainty there? It strikes me it could be rife with lots of peril. I mean, if someone says I'm the father and they're not, and then you leave the kid with a person who's not the father and something goes amiss.
Certainly.
But on the other hand,
There's nothing that I found in the department's regulations that sort of imperil them to do that. What the cases that I found have to do with whether or not he has any due process rights, which he really doesn't. The cases that I found were adoption of all or lien and CCVAB, which I believe my sister also cited. And in CCVAB, they just, under 290C.
The law is, in your view, he has no rights until he establishes paternity.
Exactly.
But nothing prevents DCF from choosing to allow visitation or to work with the father before he establishes paternity.
Nothing would have prevented the department from allowing him visitation, and it often happens. The same way that some judges in some counties will actually appoint a lawyer, and this is why I made my footnote referencing adoption of Bonney, which is a non-binding precedent as to, where I would encourage this court to have this case published in order to really establish just what the obligations of the court would be.
Court or DCF?
I'm sorry?
Of the court or DCF?
Of the court. DCF, there is no binding precedent as to whether DCF has any
It's
obligation.
not going to be involved. That's, I think, why Judge Wolohojian's asking the question. I mean, the more common situation here, I assume, is not when the mother is married to someone else at the time, but when the two just aren't married.
Yes.
Right? And then DCF is put in the position of choosing whether or not to leave the child or allow the father some visitation before the father's established paternity, but there's really no one else in the picture.
That's
Right?
correct, Your Honor. But
Well, the court's not involved at that point. DCF has to make the call.
well, DCF does have the discretion to make that call, and there, like I said, there is no binding precedent as to
So
whether or
I'm
not
confused
they're
as-
obligated to do that.
So I'm confused as to what obligation you're saying the court would have in that circumstance.
What I have found is that the obligation that I'm actually, is that the cases that are cited in Bonney, especially a matter of JVS, is that the putative father has no due process rights whatsoever.
Beyond notice.
Beyond notice, and he has the ability to establish paternity, but beyond that, there's nothing. Here, he did.
So what do you think is the question? Because it intrigued me that in your brief, you said, oh, we think we need some, published precedent on this. I'm not sure I understand what the question is that you think deserves some kind of attention from this court or publication.
The question is whether at the inception of a case, as to whether a father has any due process rights, given the court's practice of sometimes appointing counsel, sometimes not appointing counsel, and the binding precedent that is published of where he would have no rights to participate other than notice to an adoption. And even then, it would be if there was some clear and convincing evidence that there was a substantial relationship between him and the child, and that simply isn't present here.
So can I ask, what is it that you would propose that this court say on that issue, from your perspective?
I would just ask this court to make clear that in care and protection cases, from the inception of the case, putative fathers lack a due process right until the establishment of paternity.
In terms of they lack the right to representation by counsel.
Yes, Your Honor.
That's the due process right
Yes,
you're
Your
talking about.
I see my time is almost up. I would rest on my brief.
As well as notice and an opportunity to be heard.
I'm sorry,
They
Your Honor.
have the right to notice and an opportunity to be heard.
I think he's only arguing that they don't have the right to counsel.
That's correct.
He's not arguing other due process rights are absent, unless
correct.
I'm incorrect.
Okay.
All right, let me see if there are any other questions. No,
Thank
with
you.
that, thank you both. It's an interesting case. We've been aided by your arguments and by your briefing, and with that, the case has been submitted. The next case is 2022 P1262, John Thomas O'Donnell versus Kylie Christine Granfield. And I believe it's Attorney Stewart.
Yes, Your Honor.
All right, well, take your time.
Your Honor, John Stewart for the appellant John O'Donnell. If it please the court, it is our position that Judge Randall in the probate and family court committed a number of errors. She committed an error in determining the amount of Mr. O'Donnell's gross income, and as a result of that, she came up with an incorrect number for his child support. In making that order, she also, and I'm going to take a little bit of liberty here, but she gave unlimited extracurricular expenses that Mr. O'Donnell had to pay. It actually ended up being $466 a week, about $24,000 a year, which, given the circumstances, is an extraordinary amount of extracurricular expenses.
For better or for worse, if you have kids who are playing on AAU teams, travel teams, all-star teams in various sports, isn't that kind of about the going rate these days? If they're playing soccer, one of the club soccer teams would play, in this case, lacrosse and hockey, you got the equipment, you got the travel, you got the tournaments that are probably in another state or if not another country sometimes.
Your Honor, she's playing field hockey, she's playing ice hockey.
Right.
She's having games every night of the week and 2 games on weekends.
And the mother is the person who gets to make the decisions with respect to whether or not that's appropriate.
Well, we're coming to that. So essentially, Mr. O'Donnell was paying
And didn't the judge split, the judge split it, right? So mom was taking half of it.
Your Honor, yeah, you're right. So he's paying half of that. He's paying $12,000 a year, which is about $250, a little less than that, a week. And if that was his only expense, the thing is, he's got child support, which is $700 a week. He's got this, he's paying for his first daughter child support to his first wife, $300 a week. Then he's paying taxes. He's paying for the private school.
Let me stop you. And let's go back to the beginning. I thought you were going to make an argument that private school was not authorized, but let's
Yes, Your Honor.
Let's leave that aside for a moment, and we'll get to it. Let's start with the first thing you said, which is the judge miscalculated the father's income. I think the judge brought it in at $270,000 a year. What do you say the right number is?
Your Honor, I think that she took an unreasonable and to the point of capricious view of his income. He isn't making $5,000 a week. He's making more like $2,000 a week, and he's having his business pay for a lot of.
In your view, the father's income should have been $102,000?
Your Honor,
that's what he actually earned, right? That would be his wages.
That's the gross income for his business.
No, the business also had profits on average of $130,000 a year over the 3 years prior.
The difficulty, Your Honor, is
you have to answer the questions if you're going to make the argument and have us understand it.
Here's where I'm coming from, Your Honor. The court erred in the 3-year average where one of the years doubled because
take
of the
the
amount of
92,000 out. Then the average is 100,000 a year plus the 102. So we're at least at 200,000, right? You understand what I'm saying? You were just about to tell me about his PPP payment of $92,000. Take it out. Who cares? All right? Then the average for the 3 years prior of his business earnings was $100,000 a year. And he was paid out $100,000 a year. That's 200. So when you stand up and you argue to us, actually he's making $2,000 a week, when at a baseline it's $4,000 a week, I'm struggling.
Your Honor, that doesn't take into the fact.
What am I missing? Help me with what I'm missing.
That's why I
traveling.
use the word struggling.
He's got to pay taxes, he's got office expenses. These vehicles, I think that the court, and it's our position, the court
Isn't
erred
child
in
support done off gross income?
accepting, Your Honor, I grant you the gross, if we're being fair and we're subtracting out the PPP, it's about $100,000 a year. The gross is about 300. It's not 500.
I have a slightly different question. Are you arguing that the evidence did not support the judge's findings? Because it looked to me as though the evidence, there was evidence to support the judge's findings as to the amount of income. Right? Because there was the mother's expert who testified, and the judge appears to have accepted that testimony.
Yes, Your Honor, and we're saying...
Okay, so I take it that your argument is not that there was no evidence to support these findings. So what exactly is your argument? That the judge shouldn't have then, that the judge abused her discretion in how she weighed that evidence, or allocated responsibility for these costs?
Your Honor, we're saying that the court erred and exceeded the bounds of, obviously, if there's a meager amount of evidence, the court could potentially rely on that. We're saying there's less than that. We're saying that the court erred not only in making the credibility determinations, which is obviously the province that the court can make, but
assume that the judge credited the mother's evidence, which includes her expert evidence. Assume that the judge credited that, and that we don't second-guess that credibility determination.
Your Honor,
What's left in your argument? I'm trying to understand the nub of your argument.
Your Honor, what we're saying is that when the court accepted Mr. O'Brien, my brother's expert witness, when he testified that there was no use in a paving and landscaping business of having a pickup truck, that is beyond what a rational fact finder would tolerate.
Okay, so basically, your argument is...
When a landscaper, paver goes out and estimates a job, he's got to drive there in something other than a paving machine.
Okay, so this is useful. So you're saying that the judge's credibility determination, the judge should not have credited the mother's expert's testimony.
Your Honor, if credibility were the only thing we were talking about, we lose the case.
Okay, well, that's what I'm thinking, and that's why I'm trying to understand what your argument is, because it sounds to me like that is what you're arguing.
My argument is no rational fact finder could accept that as proven, could accept that evidence. When Mr. O'Brien says there's no possible use that a landscaper paver could ever have as necessary for his business, a pickup truck, that just isn't tenable as a rational finding.
So just assume, and I'm not asking you to accept this, I'm just going to ask you to assume this. Assume that we were to conclude that the judge could credit the expert's testimony. Assume that we make that conclusion. What happens to your argument then?
Your Honor, usually we like to say that a fact finder can accept all, none, or some of a witness's testimony. I don't think in this instance, based on this record, that Judge Randall could accept and swallow whole Mr. O'Brien's testimony. I think some of it was so incredible that she committed an error in accepting it.
Was there a Daubert motion on that? Did somebody move at trial that the evidence either failed the Daubert-Lanigan test, or that it should be stricken because it failed the Daubert-Lanigan test?
Your Honor, I'm not, can you put that a different way? Because I don't think I understood.
Well, we have a practice, which is if we think that an expert's testimony is so
Unreliable.
is so unreliable that it should not be relied on or allowed, you file a motion under a case called Daubert-Lanigan.
Right. Oh, yes.
There are two
Yes, Your
different
Honor.
cases. Lanigan is the case here in
I don't think that
Massachusetts.
that's an exclusive remedy. I think that any trial counsel could decide not to bring the motions in limine, object at the time it comes up at trial. I think,
Was that objection made, was basically part of my
and Your
argument.
Honor, there was
My
resistance to Mr. O'Brien's testimony, and
But did someone say to the judge, this is so unreliable that as a matter of law, it fails? That seems to me to be the argument you're making now.
yes, Your Honor.
And that argument was made to the judge below?
Your Honor, I think it was continuously raised below, and that issue is preserved as far as complaining about. Your Honor, what we're talking about is taking an irrational conclusion from testimony, and I think that that's always going to be an issue under Rule 52A. We're going to be able to say the facts that the conclusion was based on are insufficient for the finding, and that the court erred in accepting that testimony as proving that fact. And that's an issue
And are you focused just on findings with respect to the deduction for the truck? Or, because I didn't see the judge actually say anything about that in the judge's rationale. The judge said something about 7 cars, and then said, well, the one that I'm not going to allow is the Maserati. That's what the judge said.
What the court did is, the court felt that those were personal expenses, and all money that was paid for the Dodge Ram pickup truck and the GMC were imputed to Mr. O'Donnell's gross income.
Where did the judge say that? Because I didn't see that. I see this. I'm on page, the second page of the amended rationale. The court also makes 2 other adjustments. First, the court adds back the payments OP&L made for the father's Maserati, which is the one vehicle paid for by OP&L that the court reasonably can assume is unrelated to the business. In other words, I read that to be, I know there are 7. I'm not sure about all 7. That seems like a lot. But the one I'm pretty sure is not related to the business is the Maserati. What am I missing?
Your Honor, it was debated how much he used that for the business, and obviously that's a sports car, and he was paying $10,000 a year.
The point is that there's nothing in this finding that says that he's adding back anything for a pickup truck. She is adding anything back for the pickup truck. That finding is just about a Maserati, and then the next part is not about a car at all.
I'm looking on the decision. I'm not, okay.
It's the paragraph that is on the second page of the rationale. It's page 34 of something. I believe it would be that I read the appendix, but I'm not certain.
The addendum.
Your Honor, my time is limited. I'd like to talk about the fact that our position that the private school expenses are not provided in the statute.
Great, because that was my question.
And
So,
it's our position
Counsel,
that...
can I ask you, right there, I'm looking at it right here, and I looked at a copy, 209C, Section 9 says, look at the child support guidelines. Child support guidelines include private school.
Yes, Your
So tell us
Honor.
what we're
And preserved in
I'm
our...
missing. I'm missing.
And we argued in our brief, and I'm sure Your Honor paid heed to this, that we, on page 17 and page 19, we said that that's an overdelegation, that the child support framers exceeded what the statute provides. So it is our position that the court was without...
Whoa, slow down. I didn't get this from what you wrote, but I now understand you to be saying something like along these lines. Yes, it's true that the statute authorizes following the child support guidelines, but the child support guidelines themselves exceed some other standard. Is that your argument?
They talk about
Can you just, not to interrupt, sir, is that your argument?
Yes, there are
Okay,
circumstances
what
where...
guidelines are you pointing to that would say, because I didn't get this from your brief, what guidelines are you pointing to that say that the child support guidelines cannot say that you can authorize a payment for private school?
Your Honor, it is our position that the MC versus TK decision from the SJC in 2012 is not a precedent that provides an authorization.
Sir, this is the question. As I understand your argument now, it is that the child support guidelines, which do authorize the award of private school, have gone beyond some authorization somewhere. Where do I look to determine that the child support guidelines themselves are unauthorized?
Your Honor, we concede that the child support guidelines potentially allow for private schools, secondary school tuition. What we're saying is, in the circumstances of this case, and because the statute, the out-of-wedlock statute does not allow for, it allows for college. It specifically speaks to college, but it doesn't say anything about prior to college secondary school tuition. And what we're saying, and it's our position that we properly brought it up on several pages of our appellate brief, that's an over-delegation, that the child support framers exceeded their authority, and that the judge exceeded her authority in ordering private school.
Chapter 209C apply to an out-of-wedlock child support situation?
The statute is actually in the back of my brief, Your Honor.
Okay,
And,
all right. I'll look at that, thank you.
209C, Section 9. Very early on, it talks about college, but there are not discussions in there about private secondary school.
All right, I think we understand your argument. Let me see if there are further questions. All right, we're going to have to leave it there because your time has expired, and we have your brief. Thank you.
Thank you, Your Honor.
Good morning, Your Honors.
Attorney Mitchell Smith, or just
James
Smith?
Smith, yes.
Thanks.
Judge, it's very clear that 209C, Section 9C, says that the court shall apply child support guidelines promulgated by the Chief Justice of the trial court.
Is there some sort of document that limits, or that's not the right word, is there some sort of document that identifies what the rules are with respect to the adoption of child support guidelines?
No. The Chief Judge has made them on several occasions. They've been amended. The last
Well, I understand that, but do you understand, I mean, I don't think the child support guidelines couldn't say, well, the state has to pay. I mean, there's some limit to what they can say, right? Where does that come from? Where is the authorization with respect to the child support guidelines and what they can and can't say?
I mean, there's commentaries throughout the guidelines that make reference to cases. And I would say, quite frankly, if you look at TK, MC versus TK, and you look right at 463 Mass 226, at 238 to 239, the judge should determine whether current extracurricular and private school are affordable in the best interest of the child. So there's case law that supports this, and Section M...
Because they're following the guidelines.
They're following the guidelines, and they're following the ideas of imputation under the guidelines, and they're following the definition of income for small businesses, which is crucial in this case under Section 1C, which says that it's gross receipts for a small business minus ordinary...
It's a very odd administrative construct, okay, to say in a statute, you look to the child support guidelines, and that there's no regulation, there's nothing that says, apparently, neither one of you have been able to point me to it, how one develops the guidelines.
I can't give anything to you except that the chief judge has that right, according to the statute.
Yeah, but that right has got to be limited in some ways.
Well, I don't know how to address that, but
I understand the point.
I can address what the guidelines say, which is what I was saying. It's gross receipts minus ordinary and necessary expenses required for that business. This gentleman had 7 vehicles, Maseratis. The court only found 1 in the findings, but he had Mercedes. He had other vehicles as well. He was paying for a dog groomer. He was paying for a dog walker. He was paying for art. He paid for Mohegan Sun. He paid for his pension. He paid for his mother's health insurance. He paid for his mother's Kia. He paid for his daughter's college, which wasn't an order of the court. He paid hundreds, as my expert said, tens of thousands of dollars, which the judge found on RA 201, 202, and she calls it a myriad of expenses that we can't even quantify. There were so many expenses, and he paid for one child, which is the equitable keeps, which was an older child, but not the younger child. And what the court was trying to do was saying that that was not fair, that both kids have to, if there's enough money and it's in the child's best interest, they both should have. That's what the court was saying, and that's what the court did. Quite frankly, on his financial statement, my brother's financial statement, he doesn't have his K-1 income, which is on, and he didn't include it in the brief. I have the 2020 sub-S return in my appellate appendix. And on page 9 of it, on the K-1, there's $193,000 that was business income, nowhere on the financial statement. There's a distribution of over $30,000 on the K-1, nowhere on the financial statement. He takes a deduction for depreciation, which you don't do in probate and family court. It's specifically not allowed to be done. And so when you have essentially misrepresentations on a financial statement.
Isn't the depreciation deductible against his business expense?
It's deductible against his business, but it isn't deductible for purposes of cash flow analysis of what child support is. It's not. In fact, you have an attachment to these financial statements in probate and family court, and the attachments only have interest for the banks, but not the depreciation. Yes, depreciation comes off your taxes, of course, but it's essentially cash in your pocket. It's a tax.
Not the way I would ordinarily think about it. Depreciation is deferred maintenance is what it is, and it's a business cost.
Well, anyway. Whatever. But the point is...
I'm not sure, so whatever. Counsel, just to follow up, and it's not really a question, but just so the record is clear, if you look at the preamble to the guidelines and the commentary, it lays out pretty clearly where they come from. The Chief Justice convened a group as required by federal regulations. They hired an economic consultant. They had testimony from public attorneys, judges, court staff. They took comments. So it was a lengthy process, it seems. Yes.
I now have it here in front of me, and so there's a preamble, Judge, on page 2.
It's in the commentary to the preamble in 2021.
Yeah, commentary 2001 preamble, and it also has commentary preambles from 18 and 17.
As required by the federal regulations. So that's where it is. Yep. Okay.
Yep, it's right there. I just opened up the book, so it's right there.
All right.
So, this child has special needs. The child, as a judge found, was thriving with the private school and flourishing with the activities. There was evidence offered from Dr. Harp, her physician, how important these activities in private school were. She had difficulty in the Long Meadow schools, which are good schools, but Academy Hill did wonders for her. And mother, by the way, had sole legal custody, and I think the court raised this question in this case, and the judge makes mention of that issue in her findings. And there was no real contact, how sad this is, between this child and her father, which was another issue here. It was very sad. But mother made these decisions, the child thrived, and the child flourished with both the extracurricular activities. And the court made mother half responsible for each one of those things, the private activities and the tuition. And I will say this about credibility. The judge found, with respect to Mr. Moritz, the court did make a finding that Mr. Moritz was her live-in boyfriend. It's done 204 at the end of the findings until approximately July of 21, which is what mother testified to. Mother testified at great length that, and there's a real confusion here because there was a deposition taken in June, and then there's a trial in October, and a lot of questions came out from the deposition. Mother in the deposition thought, well, okay, he was going to move out August 1st. In fact, he moved out in July. Mother testified, we're no longer a couple. We have no longer any relationship. Mother acknowledged, to her detriment, as the court found, that she didn't keep his contribution on her financial statements previously. She did not. And she quite frankly stated that. And the court says that the court is requiring father to contribute to extracurricular camp prospectively only due to mother.
Can we go back to the private school
Sure.
thing for a moment? In your experience in this area, is that an award that's common in the child support area?
You know, it is common, in my opinion, when there is a significant amount of funds. Kavanaugh, which was a very important case recently, had a whole discussion about prep school. When does prep school start? Does it start in 9th grade? Does it start in 7th grade? And Kavanaugh comes out of Western Mass. And they determined that it can be a basis for a modification, and it can go back to 7th grade. So it isn't even just a private school.
But I think
Surely there
Kavanaugh
has, sorry.
I think Kavanaugh involved the interpretation of a agreement, right? A separation agreement.
No, but it talks about modification of that agreement.
Right, but the term prep school came from the
Prep school
obligation
was
for
in the
prep school
agreement,
was in
yes.
the agreement. That's not what we have here.
No, but you do have TK, which is
Well,
a
but TK
child out of wedlock case.
Yeah, although the issue isn't directly in front of the court in TK, surely there has to be a good reason before you are going to require a supporting parent to pay for private school when there's public school available for free.
Of course, and in this particular case, we had
So
testimony.
you would concede, of course, there has to be a good reason. It's not a matter of course.
Oh, no. I agree. You have to have something special. This child had special needs. Her physician didn't testify. We had 23379G. We had letters admitted from the doctor, Dr. Harp, about how important it was. We had testimony taken in depositions from the Long Meadow school people. We had some examinations that were taken.
Help me here.
I'm sorry. Go ahead.
No, go ahead, Bob.
So let me just, hypothetically, you have people, a father in this case, with unlimited resources, millions, hundreds of millions, let's say. And all of the child's buddies in Dover are all going to the private school, and the mother says, well, I've got legal authority to send him, and why shouldn't my son go or my daughter go with all of his or her friends to the private school of their choice? We can afford it, you can afford it. Why is that got to be some special need? Maybe it should, I'm just asking.
I don't think that's sufficient. I think in this particular case, the child had severe anxiety.
No, I'm not disputing that. I'm asking you, though, more broadly, because I think you indicated that you thought there had to be a special need. What if it was just a matter of unlimited resources? Why not?
An interesting question. I really don't know.
It hasn't been
It's not
addressed.
here, but it's an interesting question. I'm not really clear. If just because somebody has the money, then yeah, Johnny wants to go to Deerfield just because his friends are there. I don't know. I don't know.
Well, help me with how this started, though. It started during COVID.
Yeah.
Because mom works, right?
Mom works full-time.
And child's at home because the school's not servicing the children 5 days a week anymore, right?
Yeah.
So was the private school sort of offering in classroom 5 days a week?
She also started, yes, the private school was allowing in classroom and small classrooms, yes. That's what happened. Anything else?
I don't see any further questions. I
Okay.
think we understand the thrust of your argument.
I think you do.
Do you have anything further you wish to add?
No, Judge. I think
right.
the findings were
We have your
very
brief.
well thought out, and the judge was very clear.
Okay, thank you. Thank you both. Thank you both for your argument, and the case is submitted. The final case for today is Judith Mahabir versus James Crocker, number 2023P 0848. And I'm sorry if I mispronounced anyone's name. And is it Attorney Latimer you're going to be arguing first?
Yes, Your Honor, thank you.
Thank you.
May it please the Court, I am Richard K. Latimer, Falmouth, Massachusetts. And I think it's important to state at the outset that I am not here today as the attorney for Judith Mahabir pursuant to our fee agreement that was executed in 2019. I am here today as a representative of her bankrupt estate by appointment of the bankruptcy court in Boston in March of 2023. That
Can you
is
move
the
the
position
microphone
we
a
are.
little closer to your mouth? Thank you.
Did you hear what I said?
Yes.
Okay,
It's much
thank
better,
you.
though. Thank you.
Having said that, I will proceed to argue this case now on behalf of the bankruptcy creditors who have committed no wrong as alleged by the defendants in this action. I would also
think-
say...
Hold on a minute. I don't understand that you represent the creditors. I understand you still represent Mahabir,
Yes,
but that you were allowed to pursue that claim by the bankruptcy court.
Yes, but as I
But
believe
that
it was
doesn't
the...
mean the creditors are your clients.
I believe, as it was said by the, was it the Potter-Stokes, Stokes versus Potter case, that Ms. Mahabir, yes, she is the client, but she is doing so with standing now to be proceeding on behalf of the creditors.
No, I don't think that's correct, with all due respect. I think what actually means is you're still pursuing the claim on behalf of Mahabir, and that her recovery, though, is, first dibs goes to the bankruptcy estate.
Technically, I am here representing her estate, her and her husband's estate, not her. That's what the appointment is, to represent the bankrupt estate for the benefit of the
We're going to have to
creditors.
look at it, because I actually did not see that. What I saw was that you were authorized to pursue this claim on her behalf.
Because here's a technical point, but her name is the name as the plaintiff. And if there's a different plaintiff, there would have to be some sort of change.
No, there need not be a change, because the order of the bankruptcy court is that she has standing to proceed now on behalf of the creditors.
All right, I think that we're going to waste a lot of time arguing with you about this, and it's probably not essential to the issue here. The issue here seems to me whether the judge erred in dismissing this case on the ground of judicial estoppel.
Well, yes, it is. It is, in fact, it's the most salient of the several errors that the judge made. And it is the most salient because, and this was held by the Connor Stokes versus Potter case, which is in the brief, that the creditors cannot be prejudiced, even when there has been some intentional fraud on the bankruptcy court. If the action is to proceed on behalf of the estate now, as opposed on behalf of the plaintiff.
Wow, well, that's inconsistent
creditors-
with the Guay case. I mean, the Guay case, the court found that judicial estoppel applied, even though there was a disclosure of the existence of the claim to the bankrupt estate.
That was clear error. That's what I'm saying.
First
It was
Circuit's just dead wrong.
Clear error.
Is that what you mean? You're arguing to us, ignore Guay, the First Circuit is wrong.
Excuse me, Your Honor, I'm having a little trouble understanding you.
I'm trying to, the argument you're making,
Yes.
it seems to me, has a couple of levels of difficulty to it. But one level of difficulty is, I think in Guay, which is the First Circuit decision,
Yes.
okay, there was a disclosure of the existence of the claim in a Chapter 11 proceeding that was converted to a Chapter 7, and the court still said, nope, judicial estoppel applies and the claim is terminated.
That's because the court noted that, in fact, if there has been an appointment to proceed on behalf of the estate, well then, judicial estoppel will not apply. But in that case, very distinct from this case, there was no appointment as there is in this case. There was some disclosure to the trustee.
Who said, I'm not interested in pursuing the claim? The trustee said in Guay, I'm not interested in pursuing that claim, right?
Yes, in this case, the trustee said she was interested. She filed the motion, and the court allowed the motion. And once I have been appointed as representative of the estate, then
Your appointment and those events, were they disclosed to the court in your opposition to the motion for judgment on the pleadings?
yes, well, at the time I briefed this, the judge knew that that the bankruptcy court had been informed that of this case, that a new schedule had been produced to delay the discharge and to ensure that the creditors would get all of their money back, assuming this case will provide the funds to do that, which would not happen if this case is dismissed.
Let me just make sure I have the chronology correct. As I understand it, the bankruptcy court allowed the amendment to the schedule, to the
Yes.
disclosure, and found good cause for the amendment and to proceed with this cause of action on March 8th, 2023. Is that correct?
On March 9th, 2023, the court also found good cause
Okay,
for
so that's roughly it.
yours truly to appear in this case now as representative of the estate, not representative.
Okay, sir, I'm just going to have to ask you, just for my own peace of mind, I'm going to ask you to perhaps refrain from referring to yourself as a representative of the estate, because I don't think that's correct. And I don't want to continue to argue with you over that. So my question had to do with chronology, which is, I take it I am correct, that the bankruptcy court acted on the amendment and found good cause March 8th or March 9th of 2023. And then the motion for the in the Superior Court for judgment on the pleadings was allowed 2 months later. Is that correct?
Correct, Your Honor.
Okay. And Judge Englander's question was, did the Superior Court judge know about the bankruptcy court ruling before ruling on the motion for judgment on the pleadings?
And how did they know?
They were informed by my brief.
Where is that in the record,
No,
sir?
your brief does not say that. Your brief says that I have notified, we've now notified the bankruptcy court of the existence of the claim. But your brief did not say, I've now been appointed to represent the estate on behalf of, or I've now been appointed to pursue the claim on behalf of the estate. That was not in your brief because it hadn't happened yet when you filed your brief.
Well, yes, Your Honor. However, what did happen subsequent to that was I was appointed. And this has been made known to the Superior Court.
How was it made known?
It wasn't made known in that case. It's been made known in a companion case by her husband. However, here's the issue.
So hold on. Are you suggesting we can consider information that was provided in a separate case just because they happen to be husband and wife as...
However, apart from...
I just don't want to understand if that's what you're arguing. Are you arguing that that colloquial put covered the base for your client, or your then client, just because in the husband's pleadings or in the husband's case there was information that was provided to a court?
Yes, because it is common practice when a chosen action like this has been reported to the court, the bankruptcy court, with an amendment of the plan with a proposal that the creditors will be paid in full out of the proceeds of this case. It is common practice for the bankruptcy court to appoint counsel, whether it's me or not, it doesn't matter, to appoint counsel to have this case go forward for the benefit of the creditors. That's something that was argued, I believe, to the Superior Court, not the specific fact that I had been appointed, but that this had been amended, the amended plan had been...
Notified. The court was aware that you had notified the bankruptcy court of the existence of the claim before the court ruled. That is clear.
Yes.
The court references it in the decision.
And in that situation, it was imprudent for the Superior Court to just go forward on his preconceived notion about how there had been some fraud. Let's move on from that.
But I think the question is actually different, and I haven't heard the answer yet, with all due respect.
Yes.
And that is the following. Before the Superior Court judge made the ruling here on the motion for judgment on the pleadings, had the judge been informed of the March 2023 action by the bankruptcy court judge?
Well, yes.
Yes, okay, yes.
Yes, the fact that
Yes, and then I have a follow-up question. Where in the record will we find that?
I don't have my transcript here of my...
Okay, so off your memory...
Off my memory...
Off your memory, how was the Superior Court judge notified?
I believe that my brief to the Superior Court said that the action had been reported to the bankruptcy court.
But that's not my question, sir. My question was not whether you told the Superior Court judge that you had informed the bankruptcy court, but whether you informed the Superior Court judge that the bankruptcy court judge had acted.
Yes.
Okay.
The only
and so where are we going to find that?
I don't have my Superior Court brief in front of me.
Can you remember by what form you notified the Superior Court?
I remember specifically not being able to say at that point that I had been appointed, but I did tell the judge that I had moved that the motion had been filed for my appointment. And that was told to the Superior Court judge. Now, and it would have been more prudent for the judge to wait, but let's move on. I would like to get, that's the primary error where, considering the equities, as the Otis case requires, that is highly inequitable, since I am here, in fact, by appointment of the bankruptcy court in order to protect the creditor's interest in this case. Now, but let's get from the get-go. The error of the judge...
Sorry. I'm going to interrupt you because I think what is important, in addition to what we just talked about, is this. What was in the record as to where the bankruptcy stood as of the time the judge ruled? And by that I mean, it appears to me, I don't know Chapter 13, okay? But it appears to me that there had been no sort of final discharge from bankruptcy. Now, in a Chapter 13, is there a discharge?
There would be, finally, yes, but that hadn't occurred.
Had not happened.
And that, by the way, is another clear distinction with the Guay case. Very clear distinction, okay? Another clear distinction with the Guay case is it was very clear that those plaintiffs deliberately withheld information. Now, getting back to this case, the first error the judge made was he just assumed, by the simple fact that this case had not been reported.
Stay with me. I understand your argument. Stay with me. Your sister says that your client gained a benefit at the time of confirmation of the plan. As I understand it, confirmation is quite different from discharge. What do you say to her argument that your client received a benefit as of the time of confirmation?
Well, the fact is, getting back again to the fact that there was no clear evidence that Ms. Mahabir had dissembled.
It's not required.
Either at the initial filing or on...
Case law says that dissembling is not required. You're arguing to us to adopt a position that is inconsistent with the case law.
I'm not,
so maybe you should answer my question, which is, what benefit... Your sister says that your client gained a benefit at confirmation. What do you say to that? Because if there was no benefit from confirmation, it seems to me that's a pretty good argument.
Every time that the plan was amended, without disclosing this chosen action when she's being asked for liquid assets, every time she had to dispose of a liquid asset being hurt, not benefited, and she lost her Mercedes car, and her monthly payment increased every single time. So where's the benefit there? Where's the benefit resulting from that? And the fact that...
Disclosure, you say she was only being asked to disclose liquid assets. Is that because there's we'll look at this form, there's a form somewhere that says, this is what we need you to disclose, just disclose the liquid assets?
Yes. Look, when she made this...
Is that on the... So where should I look to learn that?
Okay, when she made the initial, quote, misrepresentation, it was a checkoff, item 33 of 56, where she checked off she had no claims against anybody.
Right.
Which she didn't at the time.
Right.
There's no evidence that she even knew she had a right.
My question is not about that. My question is about your assertion with respect to the amendments.
Well,
was there a particular document with a particular question on it, disclose your liquid assets?
Not on the amendments, no.
What are the amendments being filed in response to?
On those amendments, she was required to list only liquid assets because the issue was what's going to happen to the payments that are going to be made. That's the materiality. This case would have no materiality to that because whether this case had been reported or not, the question was, could she sell something right away, which she couldn't sell this case.
Sir, we're going to have to leave it here. Your time has expired, and we're going to have to rely on your brief for the remainder of your arguments.
Thank you.
You're welcome. Is it Attorney Sugumaran?
Yes, Your Honor.
I'm positive I mispronounced that, so please correct me.
You are absolutely correct. Thank you.
The chances of that seem very small to me. I have a bad record on that front. I have a lot of questions for you, but I don't want to step on your toes in terms of starting wherever you'd like to start.
Your Honor, if I may just answer two of the questions that were posed by the justices. First, your question with respect to whether the judge was aware of the fact that Mr. Mahabir had been appointed by the bankruptcy court. I believe that was never actually disclosed to the judge. The chronology, as you aptly pointed out, his response to my motion was filed in February of 2023. We served the papers in March, and by May, we had a decision, and there was no subsequent
Did you
briefing.
file your papers before or after the ruling in the bankruptcy court?
Your Honor, I believe it was before, but it would have been within days.
Okay, well, I think we can't place too much weight on who should have, perhaps in honesty, told the Superior Court judge that the bankruptcy court judge had ruled on that motion, right? Fingers could be pointed in both directions on that score. Was there a hearing before the judge on the motion? No. Okay, but neither side subsequently informed the judge that there had been an action taken by the bankruptcy court judge. Can we at least agree that once the bankruptcy court judge had allowed the motion to amend and found good cause for the amendment and authorized the claim to be pursued by current counsel, can we at least agree that the judge should not have then dismissed the claim on judicial estoppel grounds? I could not find any case close to these facts where judicial estoppel had been found.
Your Honor, my reading of the Williams versus Hanji case, which is a Seventh Circuit case, and obviously I understand that that is only persuasive guidance here, but in that case, I think that there were similar facts where the plaintiff in that case tried to disclose to the bankruptcy court after this issue had come to light through a motion for judicial estoppel, and the Seventh Circuit said no.
Did the bankruptcy court allow that claim and find good cause for the late amendment?
Candidly, Your Honor, I'm not sure.
I couldn't find these facts anywhere. It seems very weird to me that we would allow a Superior Court judge to dismiss a claim that on the ground that it hadn't been disclosed to a federal bankruptcy court judge, when the federal bankruptcy court judge has itself accepted the late disclosure and authorized pursuit of the claim for the benefit of creditors in that bankruptcy. It seems weird to me that the Superior Court would have authority to do that. And so that's what's really troubling me here in this case. And I understand that the judge was not informed of that fact, but it was your motion.
Understood, Your Honor. And candidly, I was not
I don't mean you
attuned to the
personally.
issue that would change the outcome of the decision.
Sure.
And so it wasn't a mission that was designed to deceive the court,
No,
but
I'm
rather
not
just a lack of
I'm not
understanding
suggesting-
with
I'm
respect
not-
to the import of that approval.
I'm not suggesting deception on anyone's part. I also was a little bit puzzled that no one had cited my Holland versus Kantrowitz case, which is very close to this on these facts. But I wanted to turn to a completely different issue because I want to make sure that I'm right on some of these things. On the annual or the periodic amendment schedules, your brother keeps saying that they only called for liquidated assets or liquid assets. Do you have the record in front of you? Are you able
do,
to
Your
pull it
Honor.
up? Okay, so I'm just going to use what's on page 80 of, it's Appendix Volume 2 as an example, because it's just an example that I found. I was trying to understand this argument of his. I see this section, first of all, I'm trying to figure out if it's correct that debtor was only required to disclose liquid assets. And in their section C, it says all other assets, and it refers to the same paragraph in the original disclosure that called for disclosure of the litigation. But at the top of the page, it says liquidation analysis. So I assume that's where he's getting the concept that it needs to be. So can you just explain that for me? Because it's not 100% clear to me what your view is as to where on these amendments, and if on these amendments, there was a continuing obligation to disclose the claim once it accrued.
Your Honor, I agree that the forms are somewhat confusing, but I think that the statutory obligation is unequivocal under section 11 U.S.C. 521A1.
Which applies to Chapter 13, I take it?
I believe it also, the Fitchburg case that I cited to recognizes that there is a continuing obligation for disclosure in other bankruptcy proceedings, including, I believe, Chapter 7 and 13. And so I believe that that statutory obligation is identified in the bankruptcy statutes. The obligation is a continuing one. And while I recognize that this particular...
So I don't know this, but I assume that before discharge, there's like a process where somebody says, you need to update all your disclosures now. Before I discharge you, you need to say, these are the only assets I have. Is that right?
Your Honor, I will answer your question in one moment. I just want to close your question out with one final observation, which is that in their Sixth Amendment, where they did finally disclose this asset, they reverted back to the original Form 106J and used that as the supplemental disclosure. So I think there is a process that contemplates, both the disclosure of liquid assets, but also other assets that may have bearing on the status of the estate.
Sure, assets may change.
With respect to your question, Justice Englander, Chapter 13 is a unique beast. Chapter 13, a debtor is given the opportunity to repay their debts over time to their creditors, and the creditors forbear any additional interest or penalties. And that benefit is conferred during the confirmation process. And so you'll see in my briefing that we've cited to a number of courts that have applied judicial estoppel when the plan has been confirmed versus discharge, because there's a recognition that the debtor is receiving a material benefit from that confirmation.
But the initial...
My question was different. My question was, is there an obligation under the federal law to bring all prior representations current before discharge?
Your Honor, I believe it's an ongoing obligation, and in fact, the Mahabirs showed at least some basic understanding of that requirement by continually updating their plan throughout the pendency of the bankruptcy.
Sure, but it appears to me, and no one seems to be disputing this, that the bankruptcy counsel and the counsel in this case were not somehow in or did not know each other. That seems to be undisputed, at least in this posture, that they did not know, left hand didn't know what right hand was doing. So it appears that the bankruptcy documents were being updated with what was known. It was just that counsel over there did not know about this claim. It is your client's position that these claims are time barred and otherwise are not basically have no value, correct? If that's the case, what harm accrued to your clients by not disclosing, or to the creditors or to anyone else, from not disclosing or late disclosing a valueless claim?
Your Honor, in this case, we had moved for summary judgment on the issue of statute of limitations. That motion was denied because the court perceived that there were issues of fact. We did move for reconsideration on the issue, and the court ultimately denied that motion as moot based on the motion for judgment on the pleadings. So with respect to the harm that my clients will suffer, they're going to have to now litigate this case through trial when they've believed for over a year now that there's been some sense of finality with respect to to the motion for judgment on the pleadings and and the application of judicial estoppel.
Okay,
Many
but
of them are
that's not
retired,
going to
have
be a
moved.
harm to the bankruptcy or to the creditors or, right? I mean, that's not a harm. Where is that harm? How is that a harm to the judicial process, which is what judicial estoppel is about?
Your Honor, I think in this case, it's the facts before the bankruptcy court were as follows. The Mahabirs had failed to disclose this asset, this potential claim, to their creditors for several years. Interestingly, in that same motion, we had also provided deposition testimony from Ms. Mahabir, which showed that she was at least aware of the fact that she had a claim against the defendants as early as August of 2017, 4 months before she filed the bankruptcy claim. She was asked to complete a form in which she had to disclose current employment disputes as well as potential employment disputes, and yet she answered no on those claims. She subsequently amended the claim 5 times during the pendency of the bankruptcy proceeding. In December of 2022, the record before the court shows that I notified opposing counsel of the undisclosed claim, and we discussed,
This
you know,
is an
the proper...
argument that she was dissembling or that it was intentional, but you also make the argument that that's not necessary, I think correctly. Right? So why are we spending time on that?
Your Honor, I think the ultimate question before this court is whether the Superior Court judge abused its discretion. That is, whether the outcome that the judge reached was so outside the realm of possibility that it should be overturned. And I think, given the record and the case law...
When you're dismissing a claim, you have to look at that. Okay.
Your Honor, I appreciate that this seems like a unique issue and an extraordinary measure, but I think that's in large part because the requirements for disclosure in the bankruptcy court are unequivocal. This candidly doesn't happen very much because the consequences are so severe. Setting aside judicial
but it's
estoppel...
also odd to have the judge, particularly in this context, to be acting on a motion without all the facts before the judge. And that's what happened here. And that's, to be frank, that's troubling me, especially when you're asking a judge to act on judicial estoppel grounds. The judge should have been informed that the bankruptcy court had accepted the amendment and found good cause to pursue the claim. I mean, absent that notification, it seems like a very uncertain factual basis upon which the judge could act. I mean, how can the judge be thought to have acted knowledgeably without that piece of information?
Your Honor, I do think that the Seventh Circuit's decision here is helpful guidance in that the court observed that the plaintiff was at least trying to rectify the issue, and the Seventh Circuit still found that that was too little too late.
Was it a Chapter 13?
It was a Chapter 13 case.
But there was no ruling by the court allowing the amendment and finding good cause for it.
Your Honor, I'm candidly not sure as to the answer. I will take your word for it. I did not understand the import of that particular step in the process. I would be happy to do further research on that issue to see if there are any other cases that are instructive on this. But as to the issue of whether this judge's decision was outside the realm of reasonable possibility, I think both the William versus Hanji case from the Seventh Circuit, as well as Davis versus Mitsubishi and Davis versus Village of Caseyville, both cases involving Chapter 13 proceedings where the plaintiffs failed to disclose pending employment discrimination claims are instructive here in showing that this is not an extraordinary outcome, but rather consistent with the case law.
Have you ever seen the abuse of discretion standard applied in the context where it was granted as opposed to denied? It just seems to me to be a very odd construct to say, well, you know, the judge has the discretion to dismiss the case based on multiple factors, and because the judge dismissed it, you have to decide whether that's outside the realm of reason. And have you ever, let me just go back to the question I asked. Have you ever seen that standard applied where the case was dismissed as opposed to cases where it was not?
I candidly am not sure.
Okay.
I have a question for you, if I may. Let's assume, and I'm not asking you to concede, I'm just asking you for your view. Let's assume that we were to conclude that the judge erred on the judicial estoppel piece. You still have the issues that the judge did not, that would necessarily carry with it the implication that the judge was wrong to deny the motion for reconsideration on the grounds that it was moot. In that case, what's your view as to the remedy? It seems to me that the appropriate remedy would be to send it back to have the judge consider that motion in the first instance.
I think you're right, Your Honor. I think with respect to two of those issues, further appellate guidance might be helpful in this regard. First, with the issue of the statute of limitations and the appropriate standard, and second, with respect to whether the plaintiff can maintain a civil conspiracy claim that basically stems from the same set of facts for which her 151B claim relies upon, considering the 151B's exclusivity provision.
I don't think that necessarily you want us to try to rule on the motion for reconsideration in the first instance, because first of all, we don't rule on motions in the first instance. But secondly, there is the question of whether there might be some other ground. All right, I think I have your answer.
I'm going to follow up on the question, though, because you argue essentially for affirmance on other grounds. As to the 300-day rule, the plaintiff makes the argument, hey, they transferred me from point A to point B. I didn't have to make my claim before they transferred me. And then once I was transferred, the behavior continued, and that's the point at which should have been the trigger for my having to file. What do you say to that argument?
So, Your Honor, in this particular case, there were several individual defendants that the plaintiff claims engaged in harassment. Defendants Crocker, Jackson,
I understand
Quinn,
this point, but
DeRosa.
as to the employer,
So as to the employer, with respect to the applicable standard, right, the continuing violation theory applies in harassment claims, provided that the plaintiff knew or should have known at the time that she should have been exercising her rights by seeking relief with the Massachusetts Commission Against Discrimination. Here, she testified at her deposition that in August, when she complained, before she was transferred, that she knew she had been subjected to unlawful harassment, that she believed she had a claim against defendants Crocker, Deegan, Quinn, Jackson.
you say that's the point she should have filed, even though shortly thereafter she's transferred. And I think the cases suggest that sort of operates as a reasonable reason not to file. Maybe things will work out.
She claims that she did not feel that her circumstances had changed. She was unhappy with the transfer. She testified that she was immediately confronted by defendant DeRosa.
All right, I understand the argument. Thank you.
Thank you. It's a very interesting case, and we've been helped very much by your briefing and your arguments.
May I ask one question, Your Honors? Would it be helpful or appropriate for me to review the issue that you had raised with respect to the appointment of the trustee?
No, you can check the rules. Everybody has the right to file 16L letters, but genuinely 16L letters, not other things. The rules will tell you what you can and can't file after argument, but we're not asking for additional briefing. All right, with that, the court is in recess. I want to thank everybody for their help today in making the sitting possible, and the court is adjourned.
This afternoon already. I was going to say good morning.